Ooh. There we go. The House will come back to order. Representative Moreno. I'm just used to. I'm sorry. Representative Moreno.
Thank you, Mr. Speaker. Yes, we do all look alike, Representative Pabon. Mr. Speaker, I move a call of the House.
Call of the House has been moved and has been properly sustained. The sergeants will lock the doors. Mr. Kohler, please open the machine. Members indicate your presence. And Mr. Kohler, please call the names of those who are not present. I don't know who that was more of an insult to.
That's a compliment to me.
Representative Swam, we are in the middle of a call of the House.
Mr. Speaker, I'm sure glad to see I'm not the only one who does that.
Yes, very true. I would relax the code rule for the remainder of the day, so.
Representatives Buck, Conti, Court, Del Grosso, Dorr, Everett, Fields, Garcia, Gardner, Janal, Landgraf, Lebsock, McNulty, Melton, Priola, Ryden, Schaefer, Scott, Singer, Sonnenberg, Szabo, and Vigil.
I saw that.
Okay, do these people not know what color they're supposed to press?
Yeah, some of them just don't.
Representatives Del Grosso, Garcia, Janal, McNulty, Schaefer, Scott, Sonnenberg, Szabo, and Vigil.
Yeah, Priya.
Singer and Wilson have it wrong.
Huh?
Singer and Becker have it wrong, and Becker always have it
So
wrong.
does Wilson and Maya. No, they're
They're all right.
They're right. I don't have anything. Okay.
You ready?
Do you want me to call them and ask them when we're going to get?
Yeah, can you answer when we're gonna get?
Shot you down pretty quick.
Some people, why do people, Becker, Becker. Hey, Becker, you're supposed to press the green button. The green button. Green. Green. Yo, just press the green button. Hey, okay, Sonnenberg, you want to raise the call? Representative Sonnenberg.
Thank you, Mr. Speaker. I move sine die. Oh, I mean, that's the wrong-
Hey!
move the call be raised.
The seat objection to the call will be raised. We will proceed to continue what we were doing before. Representative Kagan. Seeing no objection, the House resolves to have the committee hold for consideration, continuation of special orders. Representative Kagan will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading of the bill at length. Committee amendments will not be read unless requested, as they are printed and in your bill folders. Floor amendments will be shown on the screen and on your iPads and not read unless requested. Bills will be laid over upon motion of the Majority Leader. The coat rule continues to be relaxed. Right. Mr. Kohler, please read the title of House Bill 1388.
House Bill 1388 by Representatives Foot and Pedersen, also Senator Stedman, concerning a civil cause of action for damages that result from unlawful termination of pregnancy at any time prior to birth caused by at least reckless conduct without establishing legal personhood at any time prior to a live birth.
Representative Pedersen.
Thank you, Mr. Chair. I move House Bill 1388.
Representative Pedersen, to the bill.
Thank you, Mr. Chair. Representative Foote and I have worked extensively on this bill to address a need in our law to ensure that there are additional protections for pregnant women who are victims of intention, knowing, or reckless acts resulting in the loss of their pregnancy. Last year, we passed the Crimes Against Pregnant Women Act, which was signed into law to address the need for criminal remedies for women whose pregnancy is wrongly terminated. And this would address the civil remedies. This bill has been carefully crafted so that it will not restrict access to reproductive health care, will not establish fetal personhood, will not subject doctors who specialize in reproductive health to civil actions, and it will also not subject women to civil penalties for actions they take regarding their own pregnancies. This proposed legislation is a reasonable solution, and I ask for your support.
Representative Waller.
Thank you, Mr. Chair. Members, I'm asking for a no vote on this bill, and here's why. Representative Pedersen, I think, just said it best. She said this bill will not subject abortion doctors to civil penalties. Now, recently, for those of you that don't know or haven't heard or don't remember, there was an abortion doctor. His name is Kermit Gosnell. Was performing abortions, and in the course of performing his abortions would induce labor, have a semblance of live birth, and then would kill the baby after birth. Now, Kermit Gosnell, and let's just get this completely straight right now, Representative Foote, so you don't have to bring it up. We understand Kermit Gosnell was punished for his actions. He was convicted in a criminal court for his actions. I think that is absolutely right, absolutely just, and absolutely proper. But as this bill is currently written, the abortion doctor, Kermit Gosnell, who engaged in these live birth abortions, would be, in my mind, and as Representative Pedersen just said, immune from civil liability as it relates to this piece of legislation. Kermit Gosnell would not be held accountable civilly. I understand that he would be held accountable, still be able to be held accountable criminally, but Kermit Gosnell would not be able to be held accountable civilly under the auspices of this bill. Now, I believe the proponents of this bill are going to come up and argue different. They're going to say there are plenty of remedies out there available to provide civil remedies for circumstances in which Kermit Gosnell have engaged in. I believe that is completely inaccurate. On page 5 of this bill, it's under section 1321-1206-1B. The bill says a healthcare professional, as defined in section 1364-2024A, Kermit Gosnell, to the extent that the healthcare professional is engaged in providing healthcare services to a pregnant woman with her consent or where her consent is implied by law, will be immune from liability. That is Kermit Gosnell. Now, we heard in committee yesterday, Representative Pedersen said time and time and time again, his actions weren't legal. Members, I'm here to tell you, this doesn't say anything at all about his actions having to be legal. It doesn't say in providing legal health care services. This bill simply says in providing health care services. It says in providing health care services with the consent of the mother or the woman. Well, Kermit Gosnell was performing abortions that were performed with the consent of the mothers in this case, or in these cases. This is what he was convicted of. Now, a criminal court said his actions weren't legal, but this bill doesn't have that requirement. This bill doesn't say that he's immune from liability only when his actions are legal. It says Kermit Gosnell is immune from liability, period. We cannot have this, members. We need to have every single remedy available for cases where doctors, butchers, like Kermit Gosnell, engaged in these horrific actions of performing a live birth and then killing the baby after it's born. We need to have circumstances where there's not only criminal penalties available, we need to have a circumstance where civil remedies are also available for butchers like Kermit Gosnell who engage in live birth abortions. It is absolutely appropriate for us to have this. But this bill provides immunity for a butcher like Kermit Gosnell. It just simply does. It does because it doesn't say Kermit Gosnell, that butcher's actions have to be legal. It just says he has to be performing a medical procedure with the consent of the woman. And I think that's exactly what this butcher was doing when he killed those babies. He was performing an abortion, something that he was allowed to do under the law, and he was performing those abortions with the consent of the mothers. Now, he engaged in butchery in the performance of those abortions. He engaged in illegal activity in the performance of those abortions, but this bill doesn't say anything about his activity having to be legal. This bill just simply says he is immune from liability if he is providing health care services to a pregnant woman with her consent. That's what he was doing. This bill is going to do nothing more than protect butchers like Kermit Gosnell. I ask for a no vote.
Representative Foote.
Thank you, Mr. Chair. And, you know, I was also listening to what Representative Pedersen said, and I heard something a lot different than what Representative Waller apparently heard. There is nothing in this bill that would offer immunity to somebody like Kermit Gosnell. And, you know, I'm just a simple suburban lawyer, Representative Gardner, but one thing I'm having trouble connecting the dots here is that how is it that if there's an act that's performed like we talk about with Kermit Gosnell, that somebody couldn't come in and sue for wrongful death? Somebody couldn't come in and sue under medical malpractice. Somebody couldn't come in and sue under any kind of negligence claim if the facts fit. There's absolutely nothing in this bill that precludes that or changes that. This bill is related to the particular chapter and article, and it says so right in the bill. It has nothing to do with medical malpractice, negligence claims, wrongful death, or any other civil claims. So I'm just not quite getting the connection. Maybe you can enlighten me, Representative Walter.
Representative Salazar.
Again, doesn't go any lower than this. Jeez Louise, I hate it when I do that. Thank you, members. And I would like to correct something that was stated by Representative Waller. A person would have claims against someone, a butcher like Gosnell. We have torts called extreme and outrageous conduct. We have torts called negligence per se, because very, very directly to the facts, his acts were illegal in the state of Pennsylvania, as they would have been illegal here in the state of Colorado. There would have been a multiplicity of actions that could have been taken against Kermit Gosnell. And so for someone to come up here and essentially say that no one would be able to go after him, I don't think that that's necessarily correct. I think that even Representative Waller would agree that there are actions that can be brought against Mr. Gosnell. And so please don't drink the Kool-Aid on this one. This is a good bill that provides remedies, and I ask for a yes vote.
Representative Waller.
Thank you, Mr. Chair. Representative Salazar, Representative Foote, words have meaning. You're both attorneys. I think you know that. Words have meaning. Not once did I say in my discussion down here that a wrongful death action could be brought. I didn't talk about that. I didn't say it couldn't be brought. I didn't say that a medical malpractice claim couldn't be brought as well. What I said was this bill, as it is written, prevents or provides immunity from liability in charges under this bill, in civil actions under this bill for abortion butcher Kermit Gosnell. That's what this bill does. This bill protects Kermit Gosnell, butcher Kermit Gosnell, from a civil cause of action for damages that result from unlawful termination of a pregnancy at any time prior to birth caused by at least reckless conduct without establishing legal personhood at any time prior to the live birth. Under this bill, abortion butcher Kermit Gosnell has immunity from liability. That's what I have said time and time and time and time again. Under this piece of legislation, abortion butcher Kermit Gosnell could not be found civilly liable. Now, maybe under other remedies in the law, Kermit Gosnell could be found civilly liable. I didn't say that he couldn't. I said under this piece of legislation. Under this piece of legislation that's supposed to provide civil remedies for pregnant women, under this piece of legislation, abortion butcher Kermit Gosnell's given a pass. And I don't think that's right. I think that's inappropriate. I think if we're going to be passing legislation, we should hold all people accountable. And we should especially be holding butchers like Kermit Gosnell accountable for his actions. We shouldn't be giving him a free pass.
Representative Pedersen.
Thank you, Mr. Chair. And I just wanted to talk about the regulations that currently exist out there. We're trying to fill a void in our law to provide a specific remedy for women who are pregnant. If I was pregnant and somebody wrongfully, intentionally, knowingly, or recklessly harmed me and I lost my pregnancy due to this, I would want to have civil remedies. That is what this is about. While I applaud your political shenanigans, let's get back to the bill and what this is actually about.
Representative Pedersen, please. I think Representative Waller has a valid objection to describing another member's statements at the well as political shenanigans, and I'd ask you to decline from doing so.
Thank you, Mr. Chair. So currently, reproductive health care providers are subject to professional regulations like all other healthcare professionals. These include regulations overseen by the State Board of Medicine, the State Board of Nursing, the State Board of Pharmacy, the Colorado Department of Public Health and Environment, the Department of Healthcare Policy and Financing, and the Federal Occupational Safety and Health Administration. This bill does nothing to diminish these multiple levels of sources of oversight. This doesn't take away any options from a woman, it only gives her others. So I ask for your support.
Representative Gardner.
Thank you, Mr. Chair. Well, members, I have to tell you, this particular issue is one that I sort of was willing to accept. I have other concerns with this bill, but I think a little intellectual honesty in this business goes a long way. This bill has a specific exception. It's on page 4. says exceptions to liability. So it's exceptions to liability under this bill, and this is what Representative Waller is talking about, and no one seems to want to look at directly and say, yes, that is a fact, or no, that's not a fact, or that's a fact because, or it's not a fact because. It says nothing in this Part 12, that's this bill, shall create liabilities for damages or permit a cause of action against. You go to B. A healthcare professional, as defined in Section 1364-2024A. If you go there, you're going to find out it includes physicians. To the extent that the healthcare professional is engaged in providing healthcare services to a pregnant woman with her consent or where consent is implied by law. Kermit Gosnell was providing a physician, a licensed physician in Pennsylvania, was providing abortion services to pregnant women with their consent. He was engaged in the most gruesome, inhumane of acts. But those acts were consensual.
Representative Gardner, hold on a second, please. Members, the noise level is starting to rise here. Please keep a lid on it. Please. Members, guests, on my right, please keep it down.
Thank you, Mr. Chair. I'll try to speak lower.
No, not you, Representative Gardner.
Thank you, Mr. Chair. Members, Kermit Gosnell was engaged as a licensed physician in providing medical services with the consent of the pregnant woman. And as I said, they might have been inhumane. They were inhumane. They were gruesome. They were indescribable. But it is clear that he was exempted from liability. That kind of a person and that kind of an act is exempted from liability under this act. And if that's not the case, I invite someone to come down here and engage with me as to why this particular provision doesn't mean that.
Is there any further discussion of House Bill 1388? Representative Waller.
Thank you, Mr. Chair. And Representative Pedersen, I certainly take exception to your comment that I was doing nothing more than engaging in political shenanigans. I apologize if you think trying to protect pregnant women from butchers like Kermit Gosnell is political shenanigans. I'm sorry for that, but you know what? I'm going to work hard to protect pregnant women from butchers like Kermit Gosnell. I think that's perfectly appropriate to do, and I don't think that's engaging in political shenanigans in any way whatsoever. Trying to protect pregnant women from butchers like Kermit Gosnell is not a shenanigan. It's something that needs to happen. We need absolutely to protect pregnant women in the state of Colorado. We do not need to protect abortion butchers like Kermit Gosnell. We don't need to protect abortion butchers like Kermit Gosnell through pieces of legislation like this. That's not political shenanigans. That's common sense, doing what's right. Kermit Gosnell does not deserve our protections. He does not deserve protections under Colorado law. Pregnant women do. That's not political shenanigans.
Representative Pedersen.
Thank you, Mr. Chair. And currently under law, women, if they were to ever face something as horrible as what Gosnell did to women in Pennsylvania, they are protected by the law. Unfortunately, there's women that have, this has actually happened in Colorado, where they weren't protected, where somebody wrongfully, intentionally, or knowingly hurt them and resulted in the loss of their pregnancy. This is a specific thing that we're trying to address. Also, I want to point you to page 4, line 15B. Nothing in this Part 12 is intended to alter, replace, limit, supersede, or in any way restrict any provision of the Healthcare Availability Act, Article 64 of this title, or any successor statute. So we aren't taking away any remedies. Like I said, currently under law, women are protected if something as horrible as Gosnell happened. This would add other options for a lawyer to pursue and also target our very specific and tragic, rare circumstance that we're trying to address in Colorado.
Representative Gardner.
Thank you, Mr. Chair. So the way I understand that, Representative Pedersen, is in Colorado, there aren't remedies right now for people in the situation of Kermit Gosnell, and we want to provide a remedy. But oh, by the way, when we provide a remedy by this Part 12, this bill, we want to make sure and put an exception in here that says a healthcare professional like Dr. Gosnell won't be liable under this act. I mean, this is, it seems to me like you're trying to have it both ways. Either we don't need this bill at all because there are remedies that exist and it's fine, or there aren't remedies. They had remedies in Pennsylvania, but there aren't remedies here, and we need to provide a remedy. But oh, by the way, let's put an exception in this bill to make sure that the very thing we're talking about isn't given a remedy. It seems to me that we're trying to have it both ways here.
Representative Foote.
Thank you, Mr. Chair. You know, members, this is where we're at right now. We don't have remedies for an intentional, reckless, or knowing act that causes an unlawful termination of pregnancy. We don't have it under the Civil Code. It does not exist. It does not exist. What we do have, though, we have other negligence actions, we have medical malpractice, we have the criminal code. All of those things would apply to acts that we've been talking about here, all of them. This bill does nothing to change that. Now, why do we need this bill, though? Why do we need this bill? It's not because of what we've been talking about so far. It's because when there are the rare and tragic circumstances that have happened in the state of Colorado, where a woman loses her pregnancy as a result of somebody performing an intentional, knowing, or reckless act against her, there is no civil remedy. A woman who gets slammed into by a drunk driver after reckless driving, who ran a red light and she lost her pregnancy, there is no civil remedy right now. Nothing. For an intentional, knowing, or reckless act. This bill provides that. If, during a car chase, like what happened in Mesa County a few years ago, a woman who was pregnant is slammed into by a driver that's driving recklessly, she loses her pregnancy, there is no civil remedy for that intentional, knowing, or reckless act. This bill will create it. And this bill will create it in a way that's narrow, in a way that makes sense, and in a way that should be adopted here in Colorado, because we want to make sure that these women have a remedy. We want to make sure that the damages are addressed in a civil way. We want to make sure that we go down the route that we did last year with the criminal code and do the same thing in the criminal code to address these wrongs. That's why this bill is being brought. It's not changing what already exists in the other parts of the law. That's why we're asking for a yes vote on this bill.
Representative Salazar.
Thank you, Mr. Chair. And Representative Gardner, you're right. We should be intellectually honest. So let's take a look at the plain language, what you're talking about in terms of exception to liability, because you're talking about Kermit Gosnell. Let's be intellectually honest. Was Kermit Gosnell acting in his capacity lawfully as a physician when he did what he did? No, he was not. Because the only way that you can act in the state of Colorado, the only way that you can act within the aspects of your license is if you are complying with the law. So, if you take a look at exceptions to liability, was he acting, was he engaging in providing health care services, meaning that it has to be legal? He wasn't operating in a legal fashion because he was breaking the law to a pregnant woman with her consent. Did they consent to be butchered? They did not. That's being intellectually honest. So if I was an attorney and I wanted to bring a claim against Kermit Gosnell, I would not only bring negligence per se, and you didn't battle against negligence per se. What's negligence per se? Is that there's a law that protects people that is being broken, which causes injury. You didn't say anything about that, but you could bring that claim. You could bring a medical malpractice claim. You could bring extreme and outrageous conduct. And maybe you could bring something under this bill because the person was not operating within the legal limits of his license, because it talks about healthcare services, and he certainly wasn't operating with her consent. So quite possibly, if you want to be intellectually honest, Quite possibly, one could argue that you could bring such a claim under this bill against a butcher like Kermit Gosnell. That's being intellectually honest. I ask for an aye vote on this bill.
Representative Waller, Representative Gardner.
Thank you. Well, Representative Salazar, I do want to be intellectually honest, so let's back up all the way. Representative Foote says, well, there's no remedy now. There's no remedy for the pregnant woman who gets hit in the crosswalk. She has no remedy. Well, she does have a remedy. It's the same remedy she'd have on the operating table at the hospital. That's a negligence action. It's the same remedy. And this bill, by bringing it, and by the arguments from this side of the aisle about the bill, is there needs to be something more than negligence that protects that woman. There needs to be some greater remedy. Okay, I agree with you. You know, that woman in the crosswalk needs some greater remedy than simple negligence against her. We've got to protect the unlawful termination of her pregnancy. Oh, but by the way, we need to put an exception in for that pregnant woman if she makes it across the crosswalk, walks into the emergency room and says, I think I'm having a problem with my pregnancy. And in that hospital, that doctor behaves intentionally, knowingly, or recklessly, which might well happen. It's sad when it does, but it does. She doesn't get a remedy. Let's be intellectually honest. We want to provide a remedy for pregnant women in crosswalks. We don't want to provide a remedy for pregnant women in hospitals. We've been pretty clear about that in this bill. That's what's going on. Nothing in this Part 12 shall create liability for damages or permit a cause of action against a healthcare institution, a healthcare professional. We need a remedy. Oh, we need a remedy because there's not a remedy in Colorado now, but let's not have a remedy at the hospital door. Let's hold the driver, the reckless driver, liable, but let's create an exception. Well, that's what I'm talking about when I say intellectual honesty. That's what I'm talking about, Representative Salazar, when I say let's be intellectually honest. That's what we're doing here. If you want to argue that's good public policy, argue that's good public policy, but let's be honest about what we are doing.
Representative McNulty.
Thank you, Mr. Chairman. Representative Salazar, being the keen lawyer that you are, show me where the state statute includes your definition of health care services. Show us where that is, because this bill, as written, puts pregnant mothers at risk. Representative Salazar, show us where that definition is, and we'll continue this conversation.
Representative Waller.
Thank you, Mr. Chairman. And I got to tell you, Representative Foote, you have me a little bit confused now. You originally said, well, there are other remedies that can be brought under the law, wrongful death actions. Wrongful death actions can be brought, so our bill here is perfectly appropriate. Wrongful death actions can be brought against abortion butchers like Kermit Gosnell. And then you just came down here and said, well, there are no other remedies available to mothers who lose their unborn babies. So what is it? Do we not have remedies available to mothers who lose their unborn babies? Or do we have wrongful death remedies available to mothers who lose their unborn babies? What is it? Let's pick a way and go.
Representative Foote.
Thank you, Mr. Chair. Representative Waller, you might be confused because you didn't hear me say several times that this bill applies to intentional, reckless, or knowing acts. That's in the bill title. That's in the bill. That's what we're talking about here.
And the question before the committee is whether or not to pass. Representative Gardner.
Thank you, Mr. Chair. Well, members, I said a moment ago that I was sort of willing to accept, if people would be intellectually honest about it, I was willing to accept these exceptions. I understand that the medical and healthcare community, in all good faith, has some concerns, and they want those provisions in there. But what puzzles me, and I wonder if the sponsors would be willing to answer this, there seems to be a notion here introduced. Well, let me back up. This is about a remedy for pregnant women. We need to provide a remedy. There's not enough remedy out there. Now, you know, something that hasn't been answered, and I don't want to talk about other bills, but there was a previous bill that had treble damages for this terrible stuff, and this only creates one-time damages or one damages plus exemplary damages and non-economic damages. I'm not sure that's not the law today. I'm not sure that's not the law today. We once upon a time thought that treble damages might be, the sponsors thought treble damages was the way to go, but no, we got a new bill. This is the bill we're going to talk about. It only has single damages plus exemplary damages and so forth. So you can behave recklessly, and I think maybe under this bill you don't get any more than you might get under the common law of Colorado today. So I'm not sure this remedy doesn't already exist. I invite someone to tell me why it doesn't already exist. But I begin to be a little suspicious because this bill in 3 places begins to address the concept of personhood. And everyone says to me, well, the reason that we had this language in here about personhood, for instance, on page 4 at the top, nothing in this Part 12 shall be construed to confer the status of, quote, person upon a human embryo, fetus, or unborn child, is because we don't want to confuse this. We don't want this to suddenly create a wrongful death action for this unborn baby. Now, I say, well, there's nothing here without that would do that. There's nothing in this bill. And the answer to that has been, as I understand it, and I've understood what was said in committee, oh yeah, but we're afraid that the court might interpret it that way. That the court might interpret it that way. And so we need to put that in there. And I've responded to that and said, well, okay, I get that. I get that. You got to watch these courts because, you know, I've had to pass at least one bill this session to say to a court that Representative Duran and I really meant what we meant about 2 or 3 years ago in passing a bill. So, okay, I get it. But why do we have to take a position when we do so about this very emotionally and philosophically charged issue of personhood? There's a way to avoid that. Let me illustrate this to you by making a motion. I move L011 and ask that it be displayed.
Amendment L011 has been moved and properly displayed. Representative Gardner to the amendment.
Thank you, Mr. Chair. Members, if you go to page 2, lines 7 through 9, it says, nothing in this act shall be construed to confer legal personhood or any rights associated with that status upon a human being at any time prior to birth. Now, I'll let you in on a little secret here. For those of you over here, there are some of us who believe There are some of us who believe very passionately that an unborn child at 36 weeks of gestation might actually be a person. There might be such radical people like myself who actually believe that a child not yet born that is being walked through the emergency room in a wheelchair with the mother who's about to give birth, that might be a person. I know this is a revolutionary notion, that full-term baby that is still in utero might be a person and might be entitled to the protection of the laws of the United States of America and the state of Colorado. But there are those of us who believe that and believe that passionately. Now, I'm going to be honest with everybody else and everyone here on this side. I think it gets really problematic across our society in this discussion if you march back to 8 weeks or 4 weeks. And there are people who believe passionately about that on both sides. But I'm not arguing that point today. That's for another day. I want to talk to you about the passionate belief that a child at 36, 37, 38 weeks, not yet born, but full term, according to the physicians, might actually be a person. I mean, take me out of here. I mean, have the sergeants carry me out. Take me out on the West Steps and hold me up to ridicule for such a belief. But what does this bill say? Nothing in this act shall be construed to confer legal personhood or any rights associated with that status upon a human being at any time prior to birth. All right. I understand for nearly 40 years, I guess really a good 40 years now, the debate and the disagreement around this. And I'm fine. We will continue to have that for my lifetime. But the sponsors of this bill say we're trying to provide a remedy for the mother of that unborn child without sort of going down into that road of that supercharged issue. But in doing so, sponsors, as I've told you over and over again, why do you simply negate the status of personhood and negate the status of personhood all the way up to 41 weeks if the child is carried that long? I suggest to you that this formulation that I propose here in L011 is a better formulation. And Mr. Chair, members, can I have your attention, please? This is a serious thing that I ask you to consider and to not do so simply because a Republican is in the well asking you to do it. Take a good, hard look at this proposal. This is a proposal that is not a political shenanigan. It's a proposal offered in good faith to try to accommodate those who believe that there cannot be personhood prior to birth and those of us who passionately believe that, yes, there may very well be at some time prior to birth personhood. And to say, look, if you want to create a remedy, we get that. That's laudable. Let's do it this way. Nothing in this act shall be construed to either confer or deny legal personhood to a human being at any time prior to birth. Don't construe this, courts, And people who read this, don't construe it either way. This is not about personhood. It's a debate that we are going to have. This is about a pregnant woman whose pregnancy is terminated recklessly, knowingly, or intentionally. So let's not do that. Let's neither confer or deny the status. Look at page 3. There's a legislative declaration there. It's to provide an appropriate civil remedy to a woman who suffers an unlawful termination of her pregnancy. And then it says, without establishing the legal personhood of an unborn human being. That is an implicit legislative statement that that unborn human being at no stage is a person. And that is offensive to me. But it's not necessary to the bill. What is necessary to the bill is to say this act, what the amendment says, this act shall not be construed in any way to either establish or deny the legal personhood of an unborn human being in any other legal context. Court, Coloradans who read this, legal scholars, we're not going to make a statement about legal personhood in any context in this bill. We're not going to do it. You're not right. You're not wrong. You're not right. You're not wrong. Debate for another day, another place, another context. This is about providing a legal remedy to a pregnant woman who loses her pregnancy by the intentional, reckless, or knowing act of someone. That's all. That's all this amendment does. And then if you do that, you don't have to have this construction on page 4. It's not necessary. The amendment simply says we're not going to do that in this bill. That's not what this bill is about. If, as the sponsors say, this is about providing a remedy without going down the road of personhood, I get it. I understand it. I know why you don't want to do that. I really don't want to do it either. I just want to provide the remedy. I submit to you that the way you do that does go down that road. And I propose to you in L011 a way that we don't have to go down the road. We basically say to the court and the construction, we're not going down that road. We're not going down the road that way. We're not going down the road that way. It is not in any way about this personhood issue. Not at all. This is a well-intentioned, good faith amendment to avoid this issue. It avoids it for those of you who say there is no personhood prior to live birth. It avoids it for those of you who say there's personhood at conception. It avoids the entire issue and provides a remedy for a pregnant woman who suffers the unlawful termination of her pregnancy, which is the goal of this bill. I ask for an aye vote on L011.
We are on the amendment. Representative Landgraf, you had, okay. Representative Stevens.
Thank you, Mr. Chair. Thank you, members. Members, I rise in support of this amendment. I think that Representative Gardner's reasoning is very, very clear. I think for both sides of this aisle, take the issue out. You know, I will tell you, on the personhood issue, I didn't support because my son's an in vitro baby. And my son is an in vitro baby. And I had the opportunity very early on since his inception to be able to follow my pregnancy. And I will tell you, for 8 years struggling with infertility, every woman I know doesn't say, woohoo, I have a fetus. Every woman, without a doubt, says, we're having a baby, or I am with child. And as we go along and we experience our pregnancy, then what we're saying here and what Representative Gardner is saying here by saying we're not going to deal with the personhood issue. If during that time, and I'm actually amazed. I mean, we've conferred here on page 2 that it is a human being. We've said right here, the status upon a human being at any time prior to birth. So if I'm hit by a car and my human being, which I would call my baby, is terminated, I have the right to sue. If I don't choose to carry my pregnancy to term and I show up at a clinic with God forbid, a guy like a Gosnell, what do I get? What chance do I have? Friends, listen, it just is aggravating these, Representative, the idea of political shenanigans, I get both ways, actually, Representative Pedersen. This is political to me because it's disingenuous. It's utterly disingenuous. If you want to protect women and you want to make sure they're safe, what does the personhood issue have to do with this right now? And we go with where Representative Gardner is and we say, we're not saying yes and we're not saying no. We're saying you can sue for the civil remedy. Because we've conferred, apparently it's a human being. We've said you got a human being. Now, I'm not sure, some of my friends may say, well, I don't know, it's a human being when you're fully implanted, when, I don't know, maybe after a month, maybe after 8 weeks. Friends, I saw my son at conception. My son is an in vitro baby. After 3 days, I looked in a microscope and saw him. At 3 weeks, his heart was beating. Oh, dear God, get real. You think 3D ultrasound doesn't show us these things? You don't think medical science has progressed enough that we don't know this stuff? Don't give me that. Any infertility doctor, any doctor practicing medicine in infertility knows it, so stop being disingenuous. What we're dealing with here is the issue of a human being that I'll call a baby at any time, that there should be a civil remedy for a woman. There should be, and thank you for that. Thank you for that. But don't play games. Do not play games on personhood. You stick with where Representative Gardner's going, who says, I won't confirm or deny because the woman, it's going to affect the woman. Now, do I believe this is incredibly important? Do I believe about life at the beginning of concept? My religious belief and where I am, yes, because of my experience in infertility. But that's not what we're arguing here. We're arguing about the protection of women. And so his amendment makes absolute sense. Take it out. Take it out. I don't think you need it. You've already talked about a human being. Just take the thing out and let's go on our way. And let's then deal with women getting their recompense, that they're allowed to be safe. They should be safe and secure. Okay. But please, come on. We've already said this is a human being, for goodness sakes. I mean, to say that is to deny any woman who's been infertile, who's had to go through in vitro or ZIFT or GIFT or any other method of infertility to say, well, I'm sorry, your experience really isn't relevant here. Well, hate to tell you, but it is. So members, Representative Gardner's right. Let's take this thing out. Let's not confirm or deny. Let's just leave it alone, and on we go to helping women. I urge an aye vote on this. I urge an aye vote on this amendment.
Representative Lawrence.
Thank you, Mr. Chair. And I think Representative Gardner is absolutely right. If we want to be honest about this legislation, and I keep being told that this is about allowing women to sue for civil damages when they've been injured and they've lost a pregnancy. then we need to support this amendment because this takes the whole personhood issue off the table. It shouldn't be in this bill to begin with. Because if this is about the woman, why do we have this language in this bill? Except that for some reason, we are contorting ourselves to put an issue in a bill that it doesn't belong in. This is supposed to be about the woman being able to claim civil damages for the injuries that she incurred. This isn't about bringing damages for the loss of that child. And I would echo what Representative Stevens has said. My personal belief is that that is a baby growing inside of that woman from day one. But that's not what this bill is about. This bill is about civil damages for when, through no fault of her own, that pregnancy is terminated, and she should be able to claim civil damages. But personhood doesn't belong in the language of this bill. It should be removed so that we can discuss this honestly without making this political chicanery and gamesmanship. This should be about that woman.
Lawrence, I don't permit Representative Pedersen or any other member to talk about political shenanigans, political gamesmanship, playing games with the legislature. I would really ask all the contributors to the debate to really not characterize the political strategy of the people who are advocating for or against this bill or for or against this amendment. Representative Lawrence.
Thank you, Mr. Chair. I was not attributing that to anyone. That's my interpretation of how I see how this is being read and interpreted across the spectrum in this chamber. If this is truly about allowing that woman to access civil damages for a horrific event, then let's make this only about the woman. Period. I would ask for an aye vote on this amendment.
Representative Pedersen.
Thank you, Mr. Chair. And I understand that this is a tough issue for people in this body. We are trying to walk a fine line between providing protections for pregnant women without conferring personhood. We want to ensure that there aren't possibilities of that happening by us passing this piece of legislation. So I ask for your no vote.
Representative Murray. Representative Gardner.
Thank you. Representative Pedersen, I have a question for you, if you choose to answer it. You say you're walking a fine line and you don't want to confer personhood. Do you acknowledge then that what you're doing in walking this fine line, wherever you chose to walk it, that you're denying personhood prior to live birth?
Any further discussion on Amendment L011? Representative Foote.
Thank you, Mr. Chair. Members, we asked for a no vote on this amendment. You know, the way that we did this bill and the title makes our intent clear, and you may or may not agree with it, but the intent is clear. We're creating this cause of action without conferring personhood. And like I said, you may or may not agree with it, but anything that makes that intent less clear is something that I don't think that we could support. Right now, for example, the law that we're referring to from last year, Crimes Against Pregnant Women, has the same language in it that is in this bill as well about personhood. So it becomes less clear when you create two different areas of the law with two different definitions or lack thereof definitions, or neither confirm nor deny in one, and it doesn't confer personhood in the other. Now, I'm sure that some enterprising attorney, some good attorney, will come in and start making that argument. What we're doing in this case, members, is we want to, that's the intent of the bill that we're running here, foreclose that possibility. And you know, if you look at some of the case law around this topic, what you'll see is that the courts are asking for an answer in these types of actions. The courts ask, Does personhood apply or not? And the answer that we're providing in this bill is that it does not. Unambiguously, it does not. We want to avoid confusion. We want to do our job and set clear legislative history. If we change it, it becomes unclear, and that's why we don't support this amendment.
Representative Sane.
Thank you, Mr. Chair. And when Representative Foote says this makes the bill less clear, this takes this out of the argument. Until women start having giraffes instead of babies, okay, we don't have to discuss that right now. With this amendment, we don't have to discuss if it's giraffehood or alligatorhood or personhood. We can actually get back to the intent of the bill. So I urge a yes vote on this amendment.
Representative Murray.
Thank you, Mr. Chair. I'm sort of pleading with the sponsors of the bill to consider this amendment. We want this to be a bipartisan bill. We want to vote for this bill. We're not even challenging the title of the bill, the termination of a pregnancy. We have problems with that. We're not even challenging that. We're just saying, let's leave the personhood issue out. This amendment doesn't eliminate, we could have just stripped the language about personhood. That would be our preference, just take it out, and then maybe we could agree. But what this does is say there are some who believe one way and some who believe another, and this law is not about any of this. This is not about political pollution of an issue that we all should be agreeing on, that when a pregnancy, when a baby is lost in a particular circumstance, there should be civil action. So let us all come together on this and support this amendment so that we can make a statement to the people of Colorado that not only criminal action will be taken, but civil action, and that we believe as a state it should be happening that way. Please vote yes.
Representative Landgraf.
Thank you, Mr. Chair. This bill shouldn't be about when I believe life begins or when you believe life begins. It's about one thing, and that's protecting women. With this amendment, it allows us to agree to go forward and do what this bill intends. I ask for your support.
Representative Gardner.
Thank you, Mr. Chair. Well, it's curious to me that the sponsors, as is their right and privilege, have not really faced head-on this question. They don't want to establish personhood, but what they choose to do in this bill, as it's currently written, is they avoid establishing personhood by denying it altogether prior to birth. They deny it completely. They foreclose it. They foreclose it altogether. I share their objective for this bill. Let's not establish personhood. Let's leave it alone. Representative Foote says, or Representative Pedersen, Representative Pedersen says we're walking a fine line. Well, you're not walking a fine line in my view. You chose the side of the line to walk down. The side of the line is there's no personhood prior to birth. We're not going to establish it. We're not only not going to establish it in this bill, we're going to deny it. And that is the policy choice we make in this bill. There's no fine line walking here. Once again, let's be intellectually honest. The choice that this bill makes is to deny personhood prior to live birth altogether, not to leave open the possibility that a court at some later time might find otherwise, might find that the woman who is being rolled through the emergency room door when some crazed person comes running out and shoots her in the abdomen, that might be a person. This bill makes clear that we're not going to allow that to be the case. There's no fine line walking here. We're not establishing personhood in a very clear way here by denying it altogether. There's a different way, and it is walking a fine line, and it's clearly walking a fine line, and it's saying it very clearly, and that is L011. I ask for an aye vote.
The question before the committee is whether to adopt Amendment L011 to House Bill 1388. All those in favor of L011 signify by saying aye. Aye! All those opposed say no. No! L011 is lost. We are back to the bill. Is there any further discussion on House Bill 1388? Representative Gardner.
Thank you, Mr. Chair. Well, I have tried and continue to try to find formulations of this that would work for those of us who actually believe that at 36 or 37 weeks of gestation, that an unborn human being might actually be a person, might actually be entitled to the protection of the law of the state of Colorado and the United States of America. They really might be. And so let me try another formulation. Because I think there are those who probably do agree with me. And so I move L010 and ask that it be displayed.
Amendment L010 has been moved and has been properly displayed. Representative Gardner.
Yes, thank you, Mr. Chair. Well, what L010 does is substitute so that we say, in the best example is page 3, line 10. We would then say, an unborn human being prior to 27 weeks after conception. So without establishing the legal personhood of an unborn human being prior to 27 weeks after conception, I ask for an aye vote. I ask for an aye vote, Mr.
Chair. Representative Foote.
Thank you, Mr. Chair. Members, first of all, we're going to be asking for a no vote. Whenever you do anything about viability in this bill, it's actually limiting the application of this bill. We want to protect all pregnant women, not just one, and not make a determination of viability here, but also want to protect ones that have pregnancies that are even before viability and after viability. So I think it limits. But in addition, Mr. Chair, I would ask for a title ruling at this point.
Very good. Rules that the amendment L010 is not consistent with the original intent of the bill, and it is therefore out of order. Representative Gardner.
Thank you, Mr. Chair. Well, notwithstanding the ruling of the chair, I think this is an important issue, and therefore perhaps this formulation will be better. I offer and move L016 and ask that it be displayed.
Amendment L016 has been moved and has been properly displayed. Representative Pedersen.
Thank you, Mr. Chair. I ask for a title ruling.
Title ruling has been asked for, requested. I will consult. The Chair rules that Amendment 016 does not comport with the original intent of House Bill 1388 as expressed in the title and is therefore out of order. Representative Waller.
Thank you, Mr. Chair. Now I'm a little bit confused because I didn't know that one of the rulings from the chair was if it didn't comport with the intent of the title. I thought the ruling had to be that the amendment failed to fit under the title, and I don't believe that's what you just said, Mr. Chair. You said it failed to comport with the intent of the title. So is that your ruling? Because if that's your ruling, I think we need to have debate on it. Now, if your ruling is it just simply doesn't fit under the title, which isn't what you said, words have meaning, Mr. Chair, I think we need to go back to the drawing board here. I mean, we're trying to come up with amendments that actually fit under the title of the bill, and we just need to know what target we're shooting for. Is it the target of don't comport with the intent of the title, or is it the target that's actually in the rules that says doesn't fit under the title?
Representative Waller, we're not here to debate the rulings of the chair. I'm not going to permit debate or discussion of the rulings of the chair. If the rulings of the chair are not clear enough, then that is a matter to take up with the courts, should this bill pass into law, and that is the proper venue for it. Here we are to discuss only the bill and any amendments offered to the bill, and I am going to restrict conversation to that. The merits or understanding of my ruling, I'm sorry if it wasn't clear enough for you, Representative Waller, and I'm sorry for any other members that may have not found it clear enough. It is a ruling. It has been made. It is not debatable. To the bill. Representative Gardner.
Thank you, Mr. Chair. Well, I'm not even going to debate whether or not my amendment's a stupid amendment. I don't think it is. But I'll move on. And members, I want to help the sponsors. They're concerned that legal personhood might be conveyed prior to live birth. And we had discussion in committee about what courts might do and how they might construe things, and there are a lot of examples of us saying things that we thought were pretty clear. This thing about 27 weeks, you know, I suppose that makes a choice. Since the sponsors want to ensure that at no time prior to live birth will there ever be personhood construed, I worry that a court might have an argument made by some very passionate lawyers who believe, as I do, that viability, notwithstanding that viability is a different thing, that viability of the fetus, even though there's birth, should override what the legislature says here. And for that reason, I move L019 and ask for it to be displayed.
L019 has been moved and properly displayed. Representative Gardner. What?
Members, what this amendment says is, just to be perfectly clear, we're making a legislative choice. This is not a person at any time prior to live birth, even if viable. Making it very clear, even if that is a viable fetus, we are not going to convey personhood on it. That's what the sponsors apparently want. I think if you're going to vote for this bill, you ought to be very clear. Good drafting is a hallmark of what we do here when we can do it, and I'm willing to help with that. I ask for an aye vote.
Representative McNulty.
Thank you, Mr. Chairman. Title ruling aside, which I do think lacked clarity, and certainly the debate that was had behind the
Representative McNulty, please don't discuss any rulings of the chair. This is the time to discuss only Amendment L019. Thank you, Representative McNulty. Please continue.
But you, the majority, have an opportunity to provide more clarity. More clarity for this bill, and you have the opportunity to make your statement. This issue ought to be a bipartisan issue and could easily be crafted as a bipartisan bill. We could have been done an hour ago. We could have provided civil remedies to expectant mothers an hour ago. This bill could be on its way to the third reading calendar. But the majority has denied and rejected the opportunity to do that. One of the ways in which that is done is by voting down amendments with which you disagree. You've done that. Another is by hiding behind title rulings so that you don't have to vote on uncomfortable amendments. You've done that. This amendment makes it absolutely clear. If a child is viable, is that a person? Is that child a person? The question that I had in the debate back here, which is relevant to this amendment, is what is personhood? What's personhood? Chairman said he didn't know. I don't know what personhood is. Representative Gardner's amendment allows you to say what you think it is. I, for one, believe that an unborn child is a child. I have every reason to believe that that's the case. You have the opportunity now to share your opinion. If that child is viable, is that a person? That living, breathing child that has yet to be born, is that a child? You have the opportunity to provide clarity to your chairman. You have an opportunity to provide clarity in law. It is up to you now to decide whether you're going to take that clarity.
Any further discussion of Amendment L019? Representative Foote.
Thank you, Mr. Chair, and I'm going to ask for a title ruling again.
Title ruling has been requested. The chair rules that Amendment 019 does not fit within the title. And we are back to the bill. Is there any further discussion of House Bill 1388? Representative Gardner.
Thank you, Mr. Chair. Well, members, it's bitterly disappointing to me, and I say that in all seriousness, bitterly disappointing to me that a reasonable amendment such as L011 that was offered.
Representative Gardner, please don't speak to the merits of the ruling and whether you're disappointed by the ruling. If that's what you're doing, please proceed to the bill or move an amendment to the bill if you prefer to do that.
Thank you, Mr. Chair. Well, let me go back and explain to you how my reference to Amendment L011 relates to the bill. You see, Amendment L011, which was offered and rejected and therefore did not become part of the bill which we are considering, the bill which, instead of having those reasonable changes made to L011, has left me, to come full circle, Mr. Chair, bitterly disappointed. Bitterly disappointed because on the bill, Mr. Chair, those kinds of things that would have caused the bill, Mr. Chair, to be palatable, and in fact for the bill to accomplish the purpose, the bill, Mr. Chair, let me say the bill, to accomplish the purpose that the sponsors assert was its purpose, and a reasonable amendment that was offered and rejected on the bill, a reasonable amendment that would have said, we're neither conferring nor denying personhood, now says, in essence, the bill says we are denying personhood. We want to make it clear. There is no personhood prior to live birth, is what the bill now says, instead of something that was offered and rejected. And that's why I'm bitterly disappointed about not the amendment, Mr. Chair, the bill. And so I will stick to the bill. I'm bitterly disappointed in the bill. Because the bill is more than what the sponsors say they're trying to do. What the bill does is negate personhood prior to live birth. In fact, the bill, Mr. Chair, the bill, not the amendment, the bill, probably primarily does or accomplishes the act of denying personhood, because I don't think that the sponsors have explained to me how the bill itself adds one more remedy for a pregnant woman than already exists in law. A prior bill that I won't discuss the merits of one way or the other, but simply state that a prior legislative proposal talked about treble damages and attorney's fees and all of this, which really created a new remedy. All this bill does is say that if a pregnant woman were to suffer the loss of her pregnancy, then she's entitled to bring an action to recover the following damages. Her own economic damages. Well, bill sponsors, thank you. If I get hit at the crosswalk, I'm not pregnant. Let me assure you, I'm not pregnant. You know, when you go in for these medical tests, they say, are you pregnant? And I kind of look at them and they say, just kidding. When I cross the crosswalk and I get hit, Representative Salazar, you and I both know, I can bring an action in negligence for my economic damages. It's there already. I can bring an action for my own non-economic damages if I get hit at the crosswalk. Now, there won't be for the loss of a pregnancy, but they could be for the loss of my leg or the loss of an arm or all sorts of things. I can bring my own non-economic damage. Exemplary damages. For those of you who are not lawyers, you say, well, there's something, exemplary damages. Well, you know, if you have an intentional act or a grossly negligent or reckless act, you can bring an action for exemplary damages as well. So I'm wondering, something I asked earlier of the sponsors, what is it that this bill provides for the pregnant woman that does not already exist in the common law of Colorado and in the law of Colorado for negligence, recklessness, and intentional acts? What is it that this bill provides that pregnant woman? Maybe there's something there and I just haven't gotten it. What is it?
Representative Salazar.
Thank you, Mr. Chair. Since we're to the bill, the sponsors of this bill were very clear. They were very clear about the language in here about providing a remedy that does not exist for pregnant women right now on the basis of intentional, knowing, or reckless conduct. It doesn't exist in law. And they're very clear that this bill does not establish legal personhood of an unborn human being. And there's a reason for that. Because 2 times running now, the citizens of the state of Colorado have voted and said we will not recognize personhood in the state of Colorado. It is to the bill, and I'll tell you why it's to the bill. Because it talks about it. And so the bill sponsors were very clear to adhere to the wishes of the citizens of the state of Colorado when talking about this. The other thing is that the bill sponsors wanted to make sure that they listened to the court, because the courts have said that up until this point, the General Assembly hasn't addressed this issue one way or the other. So, in this bill, the bill sponsors are addressing it clearly, unambiguously, to the point where there can be no question at all. So that way, if this issue is being litigated, the courts can say the General Assembly's intent is unambiguous. It is so clear, as a matter of fact, that that ends the discussion. And that's a matter of case law. That's why this bill, the way that it is drafted so clearly that it shouldn't be messed with. Members, I ask for your support for House Bill 1388.
Representative Waller.
Oh, thank you, Mr. Chair. And thank you, Representative Salazar, for opening the can of worms on what the voters have or have not said. I now appreciate very much the opportunity to be able to talk about this. While it's not a part of this bill per se, or necessarily, you brought the issue up, and I believe it warrants some sort of response. So thank you for opening that can of worms. But before I get to that discussion, Representative Salazar, I appreciate your very definitive assertions down here where you say this is over for all time for the courts, period. It is so clear on its face that the courts are never going to have to make a decision based on this. Well, Representative Salazar, maybe we've served in different courts across the state of Colorado, and maybe we have dealt with different attorneys across the state of Colorado, but there is nothing in statute that is so clear that it is never debated in a court of law. That's why you and I make money, because we actually debate and litigate issues in Colorado courts. We debate language in Colorado courts all the time. And for you to sit up here in your ivory tower in Denver, Colorado, saying this is an issue that's never going to be litigated is irresponsible at best. And I'll tell you, Representative Salazar.
Representative Waller, please don't characterize other members as to where they sit. Really, let's keep to the merits. Thank you, Representative Waller.
I thank you, Mr. Chair. I mean, are we gonna end up with no First Amendment privilege down here? I didn't impugn anybody's motive. I didn't call into question their motive. I simply made a statement. I made a statement that is perfectly acceptable under the rules. Now, is the chair going to start creating the chair's own rules and preventing the First Amendment debate from being able to happen in the well, or what are we going to do? How about this, Mr. Chair? What can I say and what can't I say?
You can talk about the merits of the bill and the arguments in favor of the bill and the arguments against the bill and any amendments that are offered. And please don't characterize other members as don't worry about don't please characterize other members as of how they're acting. Simply speak to the merits of the argument, and I will ask that of all the members, Representative Waller, all the members, not just yourself. That's something I'm going to ask of all members in this debate, because this is a very passionate issue, and it's easy for these things to become personalized. So that's all I'm asking for, Representative Waller. Please continue, Representative Waller.
Thank you, Mr. Chair. I would like to know where under the rules I made some sort of violation of the decorum of the House. And maybe as I'm speaking, you can find that and provide that to me, Mr. Chair, because I don't believe I violated the rules of the decorum of this House in any way. I didn't call into question anybody's motive. I just simply said it is irresponsible to make an assertion that this is never going to be a litigated issue.
Please continue.
Okay, how about this, Mr. Chair? If somebody said it was irresponsible, or if somebody said this was an issue that will now be settled for all time, and if somebody who was just standing right here a couple of minutes ago said that the courts will never have to make a ruling on this issue, if that had been said, I believe that would be irresponsible to make that sort of assertion. Right. Because lawyers, I'm not calling into question anybody, Mr. Chair.
Right. Okay. Well, let's just get to the merits of the bill, please, Representative Waller.
Okay, Mr. Chair, I think that's what we were talking about. We were talking about the necessity to have this bill be clear for courts in the state of Colorado, and it is very important for this bill to be clear moving forward. We have had member after member after member on your side of the aisle come down here and talk about the need for clarity in this piece of legislation. You've had member after member after member of your party come down here and talk about the reasons that they
Waller.
Mr. Chair, what?
Representative Waller, to the merits of the legislation.
That's what I'm talking about.
To the merits of the legislation.
That is exactly.
Tell us what you agree with in the legislation, what you don't agree with in the legislation, and why.
Okay, let me start here. Let me start here. Let's start on page 3 of the legislation at line 9. The piece of legislation at page 3, line 9 says, without establishing the legal personhood of an unborn human being. Let's start there. That's what I'm talking about. I'm talking about page 3, lines 9 and 10, where it starts, without establishing the legal personhood of an unborn human being. Now, I'm here to say that we heard member after member after member come down and talk about the need to have this line in this piece of legislation. Okay, Mr. Chair, I'm here to say it doesn't need to be here. But in order to talk about it not needing to be here, I need to actually talk about the arguments that the other side brought up. And I hope that's appropriate, because I thought that's what debate was. So, we had member after member after member come down here and say it's absolutely crucial and critical that we have without establishing the legal personhood of an unborn human being. And then we just had another member come down here and say this language settles it for all time for the courts, period, it's over. I'm here to say I don't believe, in my opinion, as an attorney in the state of Colorado who's made a living debating words in Colorado statutes, I'm here to say that to have somebody come down and say that this line in the bill establishes precedent for all time that's never going to be litigated in Colorado courts is, in my opinion, incorrect. It is incorrect to say that. I don't think that's appropriate in any way, because quite honestly, members, we need to provide the absolute best possible clarification, knowing that even if we provide the very best possible clarification, these issues are still going to be litigated in Colorado courts. That's the whole discussion that we're having here. Now, members, I'll try to move on, if it's okay with the chair, to engage in my next point of discussion, which is what this bill actually does. Members, the purpose of this bill is to provide a remedy for mothers whose babies are killed. That's the purpose of the piece of legislation. That's what it's supposed to do. It's supposed to provide remedies when a baby is killed and their pregnancy is terminated. That's what this legislation is supposed to do. That's what the title of the bill says. That's what member after member has come down here and said. They haven't used the word baby. They've only referred to them as pregnancies, but you can't be pregnant with nothing. You have to be pregnant with something, and that something in my lexicon and my vernacular is a baby. It just is. Or we can call it what the bill calls it, an unborn human being. That would be appropriate as well, I believe, to call it an unborn human being as is listed in the bill. But here's the problem. This bill says on page 3, line 9, that we are not establishing legal personhood of that unborn human being. Now, we had a discussion yesterday in the House Judiciary Committee on this bill, and I appreciated something that one of my colleagues had to say, which was currently, when it comes to non-economic damages in the state of Colorado, non-economic damages are listed in this bill, and I'll be happy to point those out so I'm not talking about something that's not in the bill. Non-economic damages are listed on page 4 at line 24. That a woman is entitled to bring an action under this section and may recover the following damages. And those are the damages that are included in this piece of legislation include not only economic damages and exemplary damages, but also include non-economic damages. Now, we had a discussion in committee yesterday, and it was the consensus or the feeling of one of the members from the other side of the aisle here, from the Democratic side of the aisle, that currently, if a mother suffers loss of their baby, she is allowed to gain non-economic damages for that loss of her baby. Because in Colorado law, non-economic damages are non-economic damages mean pecuniary harm for which damages are recoverable by the person suffering the direct or primary loss. That means in the mother's case, she can recover for the loss of her unborn child. So to put that into today's terms and today's law, what that means is if a wife loses a husband, she can recover non-economic damages for the loss of that person, that husband. Now, she can also recover non-economic damages, including pain and suffering, inconvenience, emotional stress, and impairment of the quality of life as a result of the loss of that husband. And under current law, you can still recover those non-economic damages for the loss of that baby. Under current law. Here's the problem, members. This is the problem that we're now suffering. Because we've said in this bill, and because the title of this bill says, without establishing legal personhood at any time prior to live birth, we have now said that a baby is not a being, is not a human being or a person. And so now, under this law, because we've said a baby is not a person or a human being, a mother's not going to be able to recover for that loss, because you have to actually lose a human being. You can't lose a dog to recover non-economic damages. You can't lose a car to recover non-economic damages. You have to lose a person, a loved one. You have to lose their companionship. You have to lose consortium with that person in order to recover non-economic damages for the loss. So here's where we are. Because we've now said a baby's not a person until live birth, there's absolutely no spot in non-economic damages for the loss of that baby. A mother can no longer recover the loss associated with the loss of that baby. So I have a very simple and technical, this does not, it's a very technical amendment to this bill that just says, you know what, if we're actually going to allow a mother to recover non-economic damages for the loss of, we are going to say she can recover that for the loss of this unborn human being. That's all we're trying to do here. This is an incredibly technical amendment. It doesn't confer anything. It doesn't add anything. It just says, listen, right now under current law in the state of Colorado, a mother can recover non-economic damages for the loss of the baby. We're making sure that current Colorado law is protected. We're not doing anything other than that. And so, Mr. Chair, with that, I move Amendment L014 and ask that it be displayed.
L014 has been moved and is properly displayed. Representative Waller to Amendment L014.
All right. Thank you, Mr. Chair. And I can't believe I'm about to say this, but I'm actually running an amendment that the trial lawyers like. This is a trial lawyer's dream because it expands or it protects current Colorado law, and it protects what non-economic damages can be recovered for. I probably shouldn't be running this amendment. My friends in the insurance industry probably aren't going to like this amendment because it actually protects current Colorado law that allows a mother to claim loss and to recover damages for loss related to her unborn human being. So all we've done, we haven't added any new definition to non-economic damages. It's still the same definition that's in current law. The only thing that we've done is added this technical change, which is simply to add loss of the unborn human being. So we're being perfectly clear in the statute so we can create issues that are less able to be litigated, because I will not stand down here and say this is going to resolve the issue for all time. I'm not going to stand down here in an ivory tower in Denver, Colorado and say that we're, by running this amendment, we've resolved this issue for all times. I'm not going to say that. But I am going to say this gets us closer. This creates a more clear circumstance. Because, members, make no mistake, if we don't pass this amendment, we're actually making it harder, more difficult for a mother to recover non-economic damages for the loss of her baby if that baby was still in utero prior to live birth. So all this amendment does is simply adds very technical language, loss of the unborn human being. It adds that twice in this amendment, and it only applies to this section of the statute. It's very necessary if we want to maintain the current non-economic damages provision that's in Colorado law. I ask for an aye vote.
Representative McLaughlin.
Thank you, Madam Chair. Members, I have some familiarity with this issue of non-economic damages because I've practiced law in Colorado for 40 years and I've dealt with this specific issue. And with all due respect to Representative Waller, existing law awards the type of damages that he's trying to highlight and specially award here. And I just want to read to you the law in Colorado. This is 1321-102.5. limitations on damages for non-economic loss or injury. Derivative non-economic loss or injury means impecuniary loss or harm or emotional stress to persons other than the person suffering the direct injury, so that a mother who had a claim under this statute would be able to recover this as derivative non-economic loss. In addition, non-economic loss is defined in our statutes right now, today, without this amendment, as non-pecuniary loss or harm from which damages are recoverable by the person suffering the direct or primary loss or injury, including pain and suffering, inconvenience, emotional distress, and impairment of the quality of life. So our existing statute, without this amendment, awards all non-economic damages to the mother who have a claim under the statute. So I would ask you to defeat this amendment.
Representative Waller.
Oh, thank you, Representative McLaughlin, for that clarification. Please don't go away. I'm hoping we're going to be able to have a little bit more discussion on that. You just said the key word in there. When you were talking about derivative non-economic damages, those are the damages that can be claimed by a person when they have the loss of another person. And you clearly stated it there. You said it has to be damages that are claimed by a person who has a loss of, here's the key word, another person. It has to be related to the loss of another person. That's the whole issue that we're debating here. I agree with you that that's the current state of the law. But here's the problem. Here is the problem. Representative McLaughlin, you're now saying in this piece of legislation that that baby's not a person until they're live born. So you cannot claim derivative non-economic damages for the loss of another person when that person doesn't exist. Your legislation says that person doesn't exist until they're live born. All this amendment does is clarifies that we're going to allow these derivative non-economic damages to apply to an unborn human being, because this piece of legislation puts that in doubt. I mean, you can't come down here and say derivative non-economic damages relate to loss relate to the injury suffered by a person other than the person that was injured in the first place, when there is no person in the first place. How can a mother claim these derivative non-economic damages when there's no person to claim them from? Because this bill says that person's not a person. This bill says that baby's not a person until they're live born. So now, by passing this bill, by saying that person's not a live person until they're born, we're telling the courts, for derivative non-economic damage purposes, don't consider this baby as a person. That means for courts in the state of Colorado, this is a cause of action that is taken away from mothers related to loss. All my amendment does is clarifies. Because I believe, and please correct me if I am wrong, I believe it is the intent of the bill sponsors to provide remedies to include non-economic damages for derivative loss to mothers who lose their unborn children, or as the bill states, to mothers who lose their unborn human beings. Because of the way the bill is written, those derivative non-economic damage losses are lost for all time for those mothers. This amendment does nothing more than technically clarify that. That's why it is so crucial, it is so important, if we are truly going to protect women with a civil remedy, to pass this amendment. Because let's be clear, members, if we vote no on this amendment, we are actually voting no to giving pregnant women, or giving women a cause of action who lost their unborn child. A no vote on this amendment says we're not going to give them every remedy available under the law.
Representative McLaughlin.
Members, when I read to you a law that exists in the statute books of Colorado and you think I'm not telling you the truth, read the law. If you think that I'm not telling you the truth regarding what the statute says and what the cases say, read the statutes. The fact of the matter is that non-economic damages for this type of claim are recoverable under law. And let me tell you, it's not just simply about the statute. We also have other parts of the legal system which would be completely affected by this amendment. And one of them is the instructions. The instructions clearly lay forth the claims for non-economic loss, and they would award damages for this type of claim. So again, I don't want to kick a rattlesnake any further. I would ask you not to support this amendment. Thank you.
Representative Foote, then Representative Gardner.
Thank you, Mr. Chair. Members, we're asking for a no vote on this amendment. You know, there is something in court rulings or analysis the courts use. It's called looking at the plain language. That's what you're supposed to do first and foremost when you're analyzing a statute. And the plain language here under 1321-1205 says, a woman may bring an action for damages in accordance with this Part 12 against any person who intentionally, knowingly, or recklessly caused an unlawful termination of pregnancy. That's plain language about this action. It goes on to say later, subsection 4, a woman entitled to bring an action under this section may recover the following damages: economic, non-economic, exemplary, etc. This is clear. This is the entire point of the bill. So if the plain language isn't plain enough, then I think anyone reviewing this record will see that this is also the intent of the bill, and that surely should be enough. This amendment is just not necessary. We ask for a no vote.
Representative Gardner.
Thank you, Mr. Chair. Well, Representative McLaughlin, Representative Foote, I think it gets back to my unanswered question. I think Representative Waller's taken you at your word that he's trying to clean up this non-economic damages language and so forth. Representative McLaughlin comes down and says, well, non-economic damages already includes this. So my question to you is, you've told me at the outset of this debate, this provides a remedy to women that doesn't already exist. And I read it and I say, a woman entitled to bring an action under this section may recover the following damages. Now, I've already said, you know, if I cross the street, I'm not a pregnant woman, if I cross the street and somebody intentionally, knowingly, or recklessly causes damage to me personally, I lose a leg or an arm or something, I can recover economic damages, non-economic damages, and if it's reckless, intentional, so forth, exemplary damages. And so I keep coming back to, well, what is it this bill gives the pregnant woman in law that doesn't already exist? Now, Representative Waller says, well, maybe it's to make it clear that it's the loss of the pregnancy, because when you go over here and you give this construction, you actually put that in doubt. So you throw the ball in the air without giving any more recovery. Representative McLaughlin makes a very good and compelling case. If it is indeed true that someone can already, a pregnant woman who loses her pregnancy, is terminated, can already collect non-economic damages, then when someone commits an intentional or reckless act against her, she's going to be able already, under common law of Colorado, to collect economic damages, non-economic damages, and exemplary damages. And if there's nothing more there, and no one's told me that there's any new set of damages under the law, if there's nothing more there, then the intention of this bill must be something else. And I asked what the something else was. Representative Salazar comes down and says it's to make it crystal clear in the law. Well, what it's to make crystal clear in the law is, and it's what we've argued about all afternoon, it's to make crystal clear in the law that Colorado won't recognize personhood at any time prior to live birth. That's what it's really all about. It's not a bill to provide an additional remedy, because there is no additional remedy here. It is a bill about personhood in the guise of a bill for additional remedy, and there is no additional remedy here. No one's told me there is one. I've asked it 3 times, and I haven't gotten an answer to that. I submit to you that's because there is no good answer. This bill is about what we have said it's about. It's about what the rejection of these amendments prove it's about. I ask for no vote.
Question before the committee is the passage of Amendment L004 to House Bill. Representative Gardner.
It's getting late. I want an aye vote on the amendment, however. L004 is what we're on.
The question before the committee is the passage of Amendment L004 to House Bill 13004. The question before the committee is the passage of Amendment L014 to House Bill 1388. All those in favor say aye. Aye. All those opposed, no. No. Amendment 014 fails. We are to the bill. Is there any more discussion on House Bill 1388? Seeing none, the question before the before the committee is the passage of House Bill 1388. All those in favor of House Bill 1388 say aye. Aye. All those opposed, no. House Bill 1388 is passed. Mr. Kohler, please read the title of House Bill 1375.
House Bill 1375 by Representative Del Grosso, also Senator Talktrap, concerning modifications to statutory provisions governing urban redevelopment to promote the equitable financial contribution among affected public bodies in connection with tax increment financing of urban redevelopment projects.
Representative Del Grosso.
Thank you, Mr. Chair. I move House Bill 1375 and the Committee on Finance report.
Representative Del Grosso.
Thank you, Mr. Chair. Members, good thing we got the easy bills out of the way first here so we can... the Finance Committee report, simply we did a couple of things. There was some doubt on whether or not when we were talking about the tax that people were going to have to put in if we're talking about increment. The cities were kind of worried that we were actually going to ask them to put in existing tax revenue and not just the increment. So one of the things that we added on to this report is saying that the increment only, not existing tax. And then the last piece that we did on there, there was a lot of concern that existing projects might somehow be affected by this coming into law. And as a lot of you, if you've ever done any of these economic development type projects, they take a long time to put together. Sometimes 6, 8 months, sometimes a year or a year and a half or whatever. And so we felt like that if people are already going, you know, they've been 6, 7, 8 months down the road and then all of a sudden this thing kicks into play in August, that would be kind of unfair for these people that have put almost a year's worth of work into it, all of a sudden have to stop and then basically hit the reset button. So in a fairness issue for those folks, we actually changed the implementation date of this bill to January 1st, 2015. So we gave several more months for those folks that are already out there working on these projects to go ahead and complete those. And so with that, I urge an aye vote on the Committee on Finance reports.
Representative Lepsak.
Thank you, Madam Chair. I move L020, the Foote-Lebsack-Hulbert amendment.
To the amendment.
Thank you, Madam Chair. And this amendment is to the committee report. Members, if you're looking for a compromise, this is the amendment. I served for 8 years on an urban renewal authority. For 8 years. And oftentimes, I heard from the county, Adams County, that they wanted a seat at the table. This is what this amendment does. This amendment says to our counties, we hear you loud and clear. This is the compromise. we're going to allow the counties to have a seat at the table at the Urban Renewal Authority, number one. And number two, it's going to allow us to do a study on urban renewal authorities and TIFs and make sure that we get the language right before we come back and run a bill. And I ask for a yes vote.
Mr. Speaker.
Thank you, Madam Chair. And I don't like to get up and speak against my members, but Representative Lebsack talked about how this is a compromise, or this is ability for a compromise. Can you, Mr. Minority Leader, can you have Ron put this on the, show this on the board? This isn't a compromise. This guts the bill. So we're going to put a county official and special districts on the Urban Renewal Authority? Great. Well, no one's listening to them now. So putting them at the seat of the table really doesn't change anything. This takes away the fact that the local municipalities have to put their fair share of revenue into the calculation. And we don't need to study it. All we need to do is look at this chart. This chart is what the study shows you. How much money we're talking about taking out of schools. You want to talk about the negative factor? We got $80 million that comes out of our school districts and are causing us to have a greater negative factor, if you want to talk about that. So we don't need to study this. We know the facts. The facts are the municipalities have the ability to TIF revenue from the property taxes of all the special districts, all the school districts that are in their area, and don't have to even put any of their own money at the table. This bill, can you please keep that chart up there? Thank you. This bill, all it says is you municipalities put your fair share in. If you think this is a good idea, don't TIF other people's money unless you're willing to put your money at the table as well. And that's what this amendment strikes. It says, no, you don't have to put your fair share in here. So it's okay when one community TIFs something and then another community TIFs something and we end up paying this price. Our water districts, our sewer districts, and most importantly, our school districts end up paying these prices. And we're not saying, I'd love to say you actually can't TIF this revenue from all these special districts and school districts. That's my preference. This bill is the compromise. This bill says, no, you just have to put your fair share into this. I don't think municipalities should be taking money away from our school kids and putting it into corporate welfare for what's going on into these communities. That's all this is $80 million to developers when at the expense of our kids. So if you want to talk about a compromise, this bill actually says, no, we can continue to do that, but you got to put your fair share in. That's what we're doing here. The minority leader is doing yeoman's work to try and find the right balance. And this amendment is no compromise. This amendment guts the bill.
Representative Court.
Thank you, Madam Chair. So we were in the Finance Committee until 10:30 on Wednesday night, from around 4 when we started on this bill, and we heard about 35 people come up and talk to us from both sides. But the bottom line here, folks, nobody who came up from the cities or the people involved with the city's process had any ideas for how to improve things. All they said was kill it, kill it, kill it, kill it, kill it. They didn't even come up with any proposals. And when the minority leader has talked with them through the process, we never heard of any proposals. We saw no amendments to come up with compromises. Now we come here on second reading after we were hearing this bill for 6 hours, maybe longer, with no proposals for any compromises, and now we come with an amendment that completely, as the Speaker said, guts the bill. How many of us have studies in our offices sitting on the table, sitting on the shelves? How many of us have those kinds of studies? Well, I sure do. And what happens? They sit on the shelf. If we don't force this conversation by not accepting this amendment and passing this bill, this amendment would just be another study that would sit on a shelf, and our schools and our counties and our special districts would continue to suffer. I don't think that's the way we ought to do things. I think our constituents sent us down here to do something, not just to get another study that completely guts the reason this bill was brought in the first place. I urge a no vote on this amendment. Thank you.
Representative Vigil.
Thank you, Madam Chair. Well, as a county commissioner for 8 years in Castilla County, and in one of the poorest communities in the state of Colorado, every time that somebody passes a TIF bill in the state of Colorado, I want to thank Representative Del Grosso, Minority Leader Del Grosso, for bringing this bill. This bill is the compromise. Our schools lose so much money when you have these kind of TIFs out there. So please vote against this amendment. This amendment is not a friendly amendment. As Majority Leader Ferrandino indicated, all it does is gut the bill, and then we have a situation where, well, we did something, but we didn't do anything but gut the bill. So vote against this amendment. This is not a good amendment for rural Colorado, especially the poor communities.
Representative Sane.
Thank you, Madam Chair. I'm going to show a graphic here in just a second, but if you would. Thank you. Folks, I urge a yes vote on this amendment. And a lot of the conversation that resonated for hours and hours and hours in the Finance Committee last night, it seemed like both sides were talking around each other. The county said, well, the cities have no idea what we provide. And the city said they're not providing anything within the URA boundaries. I'm sure some of them admitted we do get some services, but essentially it's like they're this far apart on what benefits there are for the system. Now, the minority leader, the speaker showed a chart. And so I am Irish, so I will call shenanigans on that, because that chart doesn't show any of the benefits of that system. It shows only what the county is not receiving. However, the county does receive money from the URA projects. And with TIF projects, there is an increased evaluation, not only within the URA boundaries, but you also need to consider what happens just outside those boundaries. When these projects are built, the counties and the special districts and the schools, they actually get more money. They get more money because all the benefit and all the building up around of these distressed areas, which are now viable, now you have more things building around those. So you actually are decreasing the negative factor with these projects. And I need it displayed. I need to add display. Thank you. So if you look up on the screen, members, that base red line, if the URA had never happened, the counties or the special districts wouldn't be getting that increased evaluation. Now you can see at the top there, that's what the cities, but that's what they use to reinvest back into these distressed areas. And we've had some testimony. One gentleman was with the city of Golden for some time, and he described this very distressed downtown. And if that URA project hadn't happened, 100% of nothing is nothing. The counties wouldn't have got that money, the schools wouldn't have gotten that money, the fire department wouldn't have got that money. But now, they've actually got more funding. If that URA had not happened, you would have more of a baseline closer to the zero mark. But now, everybody benefits. So I would say this study is a great compromise, because now we'll truly find out where are the benefits coming from. How much is the county benefiting already, and how much is the city benefiting from the services the county provides, both within the URA boundaries and outside the boundaries? This is a good amendment. I urge a yes vote.
Members, I have a very long list of people who would like to speak, so please be patient. Mr. Speaker.
Thank you. It's good to be the speaker. Thank you, Madam Chair. I have to agree, actually, in some sense, with Representative Sane about, how tax incremental financing works in the actual specific situation where that actual TIF occurs. What you don't take into account, Representative Sane, in your argument is we're looking at a broader situation. We're not looking at each TIF. The issue is I build a mall on this side of the road, then I build a mall on this side of the road. Okay? I TIF this, and that project's going to create more revenue. Yes, there's going to be more revenue because that project is created. Then 20 years later, I TIF the project over here, and I say, we're going to get more money here. Well, where does that money come from? It comes from here. TIFs do not create increased economic activity. All they do is shift economic activity. Because they shift economic activity, yes, the city might be able to steal revenue from another city and be beneficial to them, but the school districts that take into both of those cities get hurt because they're subsidizing both projects and they make no more money. So in the specifics of the actual TIF, where it works, yes, you're right. But when you look at it as a state, which we are the state legislature, we look at it for the interest of the state. We are taking money out of our schools to subsidize these malls and other projects for no benefit to any of us.
Representative Lebsack.
Thank you, Madam Chair. And I just wanted to reiterate that this is a compromise. Ladies and gentlemen, counties for years have been asking their cities for a seat at the table. For years, they've been saying the process is skewed. We need a seat at the table to discuss urban renewal authorities and TIFs in home rule cities. And you know what we're going to do with this amendment? We're giving the counties what they're wanting. I agree, counties. We need to have better communication. I had a bill earlier this year that improved the communication between the state and the counties. This amendment does that. It improves the communication between cities and their counties, and I urge a yes vote on this amendment.
Madam Majority Leader.
Thank you, Madam Chair. I stand in opposition to this amendment. I agree with those that have stated before. We have studied this issue to death. And I will just relate a little history. There have been many bills over the years in this legislature to try to address what has obviously been, because there have been many bills, some very serious issues with regard to tax increment financing. And the major reason that that has been a problem is you have one jurisdiction actually being able to take the future taxes of another jurisdiction and applying it to a development project. That's what the story has been with the cities since the early 1980s. This process has been abused since then. Now, that doesn't mean that most of us, if not all of us, who support doing something about tax increment financing don't believe that urban renewal is a good idea. Urban renewal is a very good idea. But with this amendment, we're just going to go another year. We're going to go another year down the road. There are going to be more tens of millions of dollars of property tax that are going to be taken away from the special districts, fire districts, water districts, and so forth, from school districts, and from counties. And when they rely on the property tax as their major funding source, that's a huge hit. It's been a huge hit far too long. Every time there is a bill in the legislature that looks like it might be going forward that would simply balance what goes on here, would simply make this more fair. All of a sudden, at the last minute, the Municipal League and others want to do a study. This isn't the first time that we've seen this amendment on a tax increment financing bill. And the reason for that is they don't really want to study this. They want to stonewall it. They don't want to have to move forward to change a thing. And they have made that perfectly clear over and over again. They have refused to sit at the table. They have refused to come to talk about this piece of legislation. They were there once and they said, no, we don't want to talk to you about this. They do not want to compromise. They do not want to change. And this study will not make a difference. I guarantee you we will be back next year trying to solve this problem, even if we pass this study. So I ask for a no vote. We need to do something about the abuses in tax increment financing. I applaud Representative Del Grosso for bringing this bill. It is a great solution.
Representative Fisher.
Thank you, Madam Chair. I rise in opposition to this amendment. And, you know, one of the reasons I'm passionate about this issue is that I've actually worked on trying to do some reform of the Urban Renewal Authority statutes since I first was elected, really. And I remember back in 2009, I think it was, I participated in a group, a task force that was put together by then County Commissioner Cathay Reynolds. We met, I think we were meeting like bi-monthly for pretty much through the entire summer and into the fall. And at the end of the day, what came out of it was really absolutely nothing. We accomplished really very little except bouncing ideas back and forth, and there was no real concrete result from that. And my concern is that the same thing is going to happen here. This will be another lost year of momentum that we can take right now and make a really significant and substantial incremental step toward the major type of reform that needs to occur. And I'm not sure whether the study is even going to be designed to bring back recommendations for legislation next year. So I just ask for a no vote. I have books on my bookshelf that explain all this. It's not rocket science. I don't know why we would need to study it. There's been plenty written about tax increments and what it does to local economies and how it allows one community to play off of another community, trying to basically rate each other's sales taxes. I live up in a part of the state where this is rampant, and the people that want to abuse the URA statutes have all the attorneys in the world that will find all the loopholes, and they'll be able to take advantage of this. And, you know, coming from a community that I believe is a relatively responsible user of the URA statutes, it's really hard to fight against that. There's really not a level playing field. If you want to play nice, there's always that community next to you that's not going to play nice. And so we need to address this issue now, and certainly I don't support studying it for another year.
Representative Foote.
Thank you, Madam Chair, and I'm in support of this amendment, and let me just tell you why. The Speaker said earlier, we know the facts, and we know the solution. And I would agree with the first part of that statement. I think we do know the facts, but I don't think that we have the solution here in this bill. At least I'm not convinced that we do. I think, at least based on my crash course of URAs that I've done over the last couple of weeks since this bill's been introduced, that there are abuses. As a matter of fact, there's a URA that's about 5 minutes walk away from my house that I think is being abused. But this bill wouldn't do anything to stop that particular abuse. And what I'm concerned about, if there's a disconnect between what we think is the problem and what we're proposing as a solution here, then what we end up doing is we end up eliminating the projects that are actually working in good faith, or the projects that are good projects. Matter of fact, I'm aware of a project that where the sales tax and property tax TIF is not equal, and that's because the city's putting in money up front for infrastructure, and they're taking more property tax for the TIF in order for it to occur, and they're not doing equal. They're putting some money in, but it's not equal. So what I'm concerned about is this bill would mandate equality, and I just think that's something that I'm not convinced is the right solution. I do commend, however, the bill sponsor for bringing this forward, because I do think that there are abuses, and I also think that there haven't been very successful efforts to resolve those, and I think that a bill like this can really help that. But what I'm concerned about is you're basically throwing the baby out with the bathwater here. I mean, you're getting rid of the good projects, or you could get rid of the good projects, and the cities were clear about that, at the same time as you're trying to solve, but does it really solve? You know, in the testimony that we heard, that we sat through, the counties made the case that the cities need to put skin in the game. And I'll put that a little aside because the cities disagree that they aren't putting skin in the game, but they claim that they need to put skin in the game. But again, it wasn't presented, at least to my satisfaction in committee, how that's going to solve the problem. And so that's why I'm in favor of this amendment. I hope that you will also support it.
Representative Swam, and I'll just tell you who I have. I have Swam, Sonnenberg, Loop, Labuda, Sane, Melton, Holbert, and now Landgraf.
Thank you, Madam Chair. Members, I rise in opposition to this amendment. I actually, along with Representative Court and others, sat through that very long hearing the other night. And honestly, when I went into that hearing that night in Finance, you know, this has been one of the most heavily lobbied bill of the session, in my opinion. And I had almost come to the conclusion I was going to go in there and toss a coin to decide how I was going to make a decision. But the more testimony I heard, the more convinced I was that Representative Del Grosso's approach on this bill is the correct approach. And let me just, we don't need another study. We need something to kind of level the playing field, and I think that's what Representative Del Grosso is trying to do with this bill. Let me give you two examples that are just a little bit of testimony that came out of the committee. The opponents came up first, and there was a mayor who came up, and he was asked a question. He was asked the question, what kind of services would the county provide you if a TIF occurred in an urban area? And the mayor kind of had this blank look come over his face and said, well, gosh, I don't think the county provides any services there. It's in an urban area. It's pretty densely populated, and I don't really think the county provides any services. And then later, very much later, right towards the end of the hearing, near 11 o'clock, my county commissioner, Rod Bachenfeld, came up and talked about what's going on in Arapahoe County. And you know, a couple of years ago, there was something that happened in Arapahoe County that we all know and dread. There was a terrible, terrible movie shooting. Guess who is housing that criminal in Arapahoe County Jail? They've spent millions taking care of that situation. The Judicial Department, the 18th Judicial Department, taking care of everything that goes along with that terrible event that occurred out in Arapahoe County. My friends, the counties provide services throughout the county, including the municipalities. And I think we need to put more guardrails on this process. I'm convinced when you see what happens, these TIFs often run for 25 years. The malls get a 25-year tax advantage. Guess what happens when a mall is 25 years old? It's called reblight, because malls need to be rebuilt and refurbished every 25 years. So at the end of 25 years, they just go back and get another TIF. It just happens over and over again. Malls don't last probably even 20 years before people want to move on to the next new thing. So I don't think that we need another study. I think we need, frankly, more guardrails on this TIF process. So I think this is a good bill, and I urge a rejection of this amendment. I urge a yes vote on the bill.
Representative Sonnenberg.
Thank you, Madam Chair. Members, I urge a no vote on this amendment. We have talked about urban renewal authorities and how they work every year I've been here. Every year. I've carried bills with regard to urban renewal authorities. Matter of fact, if I remember correctly, last year we offered to study urban renewal authorities, and the municipalities said, no, we really don't need to do that either because we know what they do. Let me explain how they work in my area. I vote to put a tax on myself for a fire district or some other district, a water district, in which I vote and say, I want to pay this tax so I can improve my fire department that covers my rural area or that water department. And then an urban renewal authority comes in and says, you know what? We're going to cap you, and we're going to take that input. That's what we have. That's why we don't need a study. That's why we need to pass the bill so we can have a voice on those urban renewal authorities. If our money's going to be part of that authority, we need to have a voice. We don't need to study it. Study is a way to say, we don't know what to do, let's study. Ladies and gentlemen, we know what to do. Defeat the amendment, pass the bill. Thank you.
Representative Landgraf.
Thank you, Madam Chair. Representative Foote, when you're right, you're right. I have to agree with everything you said. And Representative Sonnenberg, I just have to say that for every year for 8 years, I have heard this argument. I've heard how the counties somehow miss out. I've heard the cities complain that the counties have no reason to take their money. It never ends. It just goes on and on and on and on. And I believe that passage of this amendment would put an end to it. I think there's a possibility that they both have a legitimate complaint, I guess, for lack of a better word. They certainly have a different point. And I don't think we know the facts. We have another chart. I've got lists. We could go on all day with charts and lists and numbers proving one point or the other point. But the fact is we don't know. We don't know for sure what the impact of a URA is on the county, if there's any. And I don't disagree that there are probably bad actors out there, but do we punish everybody because of the bad actors? Do we take away everybody's rights because of the few? Or do we do a study and find out the facts once and for all? I would ask for a yes vote.
Representative Labuda. No. Okay. Representative Sane.
Thank you, Madam Chair. And as you can see what the amendment says, you're going to analyze both the positive and the negative effects of this. Now, Mr. Speaker, I'm going to call shenanigans again. This is not all about malls. This is not all about malls. The cannibalization argument falls flat, especially when you look at some of these small towns that use these URAs to rebuild these crumbling downtowns. Because if they did not use this tool, those would go away eventually. And I have met with many school districts that are in favor of URAs because they knew they would get eventually more tax revenue. And so if you can see from that chart right there, it starts rising. It's not frozen. They actually get more tax revenue as time goes on. They would get more, and this has been proven, they would get more than if that URA project had never started. So many school districts are in favor of URA. So why don't we have a study? Because again, the arguments that I heard in Finance Committee just the other night, counties didn't know exactly what monies they were getting as far as benefits, both from inside the URA and outside the boundaries. And same with cities. They said, I don't know what benefits the counties are supplying to us. So this would be a great amendment to see what's the truth. What's the truth? That's all we're asking. I vote yes.
Representative Melton.
Thank you, Madam Chair. And members, I voted yes on this bill in Finance. However, I'm also a yes on this amendment. And let me explain. I come from a district that is half unincorporated, Arapahoe County, and half City of Aurora. Now, when we say that the cities don't have any skin in the game, that is so far from the truth, because we heard over and over again from both the cities and the counties that 85% of the time they come to an agreement where the city is contributing in money, investments, infrastructure, things like that. What this amendment will do, though, is it will say that a percent for a percent isn't necessarily the right answer. We need to find what the right answer is. We need to find what the right balance is. And to do that, we need a study in order to bring us to that number. In order for us to really understand what are the cities buying, what are the counties buying. Without that, without all their agreements, beyond that 85%, we're going to end up falling back to this default that's in the original bill. I think it's a good bill. I think that the county should have a say at the table, but I'm not convinced that a percent for a percent is the right solution. A percent of sales tax and a percent of property tax are not the same thing. And so I do urge and I vote on this amendment, and let's do something so that way the counties and the cities can truly understand what the impacts are. I ask for an aye vote on this amendment.
Representative Holbert.
Thank you, Madam Chair. Sometimes it's good to be a member of the minority. Members, I ask for your support of L020. How often, and I'll answer this is the first time, have you seen the names Foote, Lebsock, and Holbert together on anything? I agree with Representative Foote and Representative Lebsock that we need to study this. We need to talk about this some more. And business is brought into a community, how jobs are brought into the community. Some of you have asked, and many have asked out in the lobby and outside the Capitol, how do you do it in Douglas County? Well, we communicate. We listen to each other. Our commissioners are split on this bill. Our communities are divided on this bill. Parker, where I live, opposes this bill and supports this amendment. You have Boulder, Thornton, and Parker coming together and saying, wait a minute, we aren't clear on this. We need to do what's right for the state of Colorado. And I'm proud to stand with my colleagues, Representative Foote and Representative Lebsock, to say, wait. We have a divide along party lines. We have a divide. We have leadership from both of our parties advocating for one side. We have members from both parties advocating for either side. This is a time where we should step back and have a further conversation, a further investigation, a study on the issue before us. The speaker said earlier that if you build a shopping mall on one side of the highway and another on the other side of the highway, and how TIF financing would affect based on when it was incorporated, I understand. But that's the kind of question that we will answer with this study. I usually don't support the punt position of let's talk about it over the summer and come back next year and solve the problem. But in this case, I need to listen to the people who I represent, the communities in Douglas County, and they're torn. The engine of economic prosperity in Colorado, the example that so many point to who ask, how do you do it in Douglas County? We're torn on this. So for this example, I would ask your support for this amendment, that we study this and pledge that I would be at the table, that I would bring the resources of Douglas County to the table to find out what is the right answer. We have a split between the associations that represent municipalities and counties. My district, the district that I represent, is a demonstration of that. There's not agreement, there's division. And this is an opportunity that a representative from Boulder and Thornton and Parker can come together and agree. Let's do the right thing for the people of Colorado. Let's do the right thing for economic development. Let's support L020 and step back from making a rash decision. I ask for a yes vote on L020, and I'm proud to stand with my colleagues, Representative Foote and Lebsack, on this amendment.
Representative Lebsack.
Thank you, Madam Chair. And I'm going to tell folks a quick story, a success story in Thornton. It's in original Thornton in Representative Salazar's district on Washington Street. And there was a burned out liquor store. The city was able to redevelop original Thornton. They were able to redevelop on 88th Avenue and Washington Street. Now if you drive by 88th Avenue and Washington Street, it's a thriving shopping center and a bank, and people are coming and going, and it's great for the economy. This is why this amendment is so important. Ladies and gentlemen, let's not stifle economic development in Colorado. Let's stand with the economic engine, our developers and redevelopers in Colorado. Ladies and gentlemen, we allow counties to have a seat at the table. That's what they've been asking for. Frankly, I think maybe that's what they deserve. And we also do not kill and stifle economic development in Colorado. I urge a yes vote on L020.
Representative Duran.
Thank you very much, Madam Chair. And I do rise in support of the amendment today. Representative Lebsack started off his comments talking about how this is a compromise. And maybe it's not a compromise at all, but I do think it is a meaningful compromise because of some of the issues with the underlying bill. You know, we have talked a lot in this chamber about process. And to me, this bill was introduced very quickly. It went to committee very quickly, and now is on the House floor very quickly. And there are many questions that still remain. I heard from the city of Denver regarding this bill. And when we look at the use of TIF, this isn't just something that is used for corporate welfare, taking money from schools to go towards some of these efforts. In fact, it was very interesting to look at an analysis that the city of Denver provided that showed that by investing incremental property tax revenues in urban infill development, the Denver Public Schools actually increases its expected property tax revenues from these redevelopment areas on average by 13.6% annually for Stapleton, Lowry, Broadway Marketplace, the Pepsi Center, and the 15-block downtown TIF. All of Denver's urban renewal projects have received the support of Denver Public Schools as well. So when we look at this issue as a whole, I would agree also actually with Representative Melton, who said that, yeah, we should look at this issue. But is this the right solution? And is this the right solution in a bill that is being pushed through so quickly in the last few days of session that I believe we do need more time? I agree with the city of Denver and some of the information that I have received regarding this topic. And so to me, this is a compromise. Absolutely, should there be a seat at the table when it comes to these decisions? With this amendment, that seat at the table will still be there. But also, we need to look at this issue a bit further instead of trying to make last-minute decisions and ramming a bill through. Thank you.
Representative Fisher.
Thank you, Madam Chair. I wasn't going to speak again on this amendment, but some of the comments from Representative Lebsack need to be addressed. And you know, if you want to study the effects of TIF, come to Fort Collins, my community. I can show you a half a dozen or more examples of projects that work and projects that are detrimental and adversarial. And there are good and bad actors on both sides. But just as an example, to counter Representative Lebsack's success story of the burned out liquor store. So the city of Fort Collins just had a URA area set up on North College that allowed the development of a brand new huge Super King Super store right across the street from an existing Albertsons. Now, the Albertsons development received no tax increment financing because people hadn't figured out all the loopholes that you can use to get tax increment financing on virtually any piece of real estate. They built it with their own dollars, made the infrastructure improvements with their own dollars in the development. So now we have a huge new development that's been subsidized by tax increments. And guess what? Now we've got a dark store sitting next to a brand new King Soopers. It's going to be dark in the very near future because they just closed their doors. They've gone out of business, the Albertsons. So what is fair about that? We just cannibalized one very successful business in favor of another huge corporate giant to move in right next door to a successful business and put them out of business. We use tax dollars to do that. How is that fair?
I'm trying to break them.
You want to study it, we've got plenty of examples like that in my part of the country. I could go on and on. The problem is now that when a tax increment is used to subsidize or incentivize a development in one community, guess what? The next community, the next time a company or a developer wants to come to another community, they're going to demand a tax increment too. So it's a never-ending cycle of more and more developers.
Mr. Minority Leader.
Thank you, Madam Chair. And members, it's probably going to come as no shock to you, but I oppose this amendment. And Representative Holbert talked about, gosh, you know, we see a Foote, Lebsack, Holbert amendment. How can that be wrong? Well, Representative Holbert, 3 wrongs don't make a right. Just giving you a hard time, Representative Holbert. But seriously, folks, try to draw it back here. I think we kind of went off on a lot of different ways here with a lot of the discussion, and I wanted to kind of go last because I wanted to kind of draw it back to say what this amendment will actually do by what it's going to cancel out in this bill. And forgive me, Madam Chair, but I kind of have to explain what the bill does and what it won't do again, what it won't do if this amendment is to pass. And members, this bill does 2 things, and this would strike out one of them. This one just says that if a city is going to obligate a certain percentage of county property tax because they think that a deal is so good in their district, that they also have to be willing to obligate the same percentage of sales tax. It's a fairness issue. And here's how it works, members, is that the cities right now have all the cards. The way the statutes are set up, and I'm not saying anybody's abusing anything or, you know, we heard a lot of people say that. I'm just going to bring a fact here that says that the way the statutes are set up, the city can obligate future property tax increments towards the TIF project. And the property tax is what counties rely on. The counties have no say in that process. They can bring an impact statement and say, gosh, you know, this is going to cost us a lot, you know, whatever to provide these services. And in some cases, the municipalities act on that. But in other cases, they don't. But they're actually not legally compelled to act on those impact statements. So as it stands right now, one municipality holds all the cards over the other municipality.
Now, we heard there was a lot of but for, well, that property tax wouldn't exist if it wasn't for this development that we're doing in our municipality. Well, the same can also be said and true about the increase in sales tax. So truly, if that increase in property tax belongs to the URA and not the counties, as what is claimed, so that's why the counties should have no right to that, why is it not the same thing that the increment in sales tax that comes from here also not belong to the URA and then also be used for those purposes as well? You can't say one municipality's sales tax doesn't belong to them, but the other one does. So what you would be doing by this study is you would be eliminating the piece that says, and I will back up 1 second, this is a default mechanism. So for instance, Representative Duran came down and talked about impacts it might have on the city and county of Denver. Well, guess what? It won't affect the city and county of Denver. If a municipality and a county government work together on a deal, this bill doesn't apply. So if they come together and says, you know what, city, county, we've got this Bass Pro Shop or whatever that's going to be moving into our community. This is how many jobs this is going to be create. This is how awesome this is going to be for our community. And those two can get together and work out, and one can say, you know what, we'll put in a bunch of infrastructure up front. Maybe you could put in some of your future property tax. We'll kind of work together and see what we can do. You've got two sides coming together to say, look at what we can do to bring this amazing project into our community, and it brings that much more credence. And if that happens, this bill doesn't apply. I heard from the city of Sterling that said, hey, please don't accept this bill or don't pass this bill because we've got a deal worked out with our county where we basically do building by building downtown of rehabbing buildings, and we use that property tax increment to pay bonds and to fund that. And my response back to them is, if you have a deal worked out with your county like that, this doesn't apply. You are not going to be required to put that sales tax in there if you've got some kind of a deal worked out with that municipality. It's only in the cases where the two sides cannot get along. Then this applies. Members, I've only been here 5 years, and I've dealt with TIF URA issues, I think, for, I know, at least 4. And we heard that, gosh, if we would have known that the counties had a problem with this, maybe we could have worked something out sooner. Well, members, I guarantee this problem has been talked about and worked about several years before any of us ever stepped foot in this chamber. And I tell you what, the counties obviously oppose this amendment because they're afraid that, you know what, if this amendment passes, it'll go to a study. And guess what? When somebody holds all the cards and doesn't have to give, what incentive is there for them to work? Great, we did a study. Okay, we did another study. How many times do we do studies down here and nothing is actually acted upon? Members, I submit to you that if you actually think that this is a problem that actually truly needs to be addressed, kicking it to a study is not going to solve that problem. That is why I'm opposed to L020, and I would hope that you would be as well.
Is there any further discussion on the amendment? Okay, a division has been called. The question before the House is the adoption of L020. All those in the chamber not entitled to vote, please be seated. Representatives McLaughlin and Representatives Kagan, could you please be seated? They don't have to be? Oh. Okay. All those in favor of Amendment L020, please stand and remain standing in one place until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place until the count is taken. The amendment is lost. Mr. Minority Leader.
Thank you, Madam Chair. I renew my moment. Sure. You know, we still have a few days left of the session, so those are going to probably be pretty long. I renew my motion to ask for an aye vote on the Finance Committee report.
Is there any further discussion on the Finance Committee report? Seeing none, the question before us is the adoption of the Finance Committee report. Those in favor say aye.
Aye.
Those opposed say no. No. The committee report passes. Mr. Minority Leader.
Thank you, Madam Chair. Members, I kind of briefly explained the bill again just a few minutes ago, and I won't put everybody through that again. But what I will say, on top of the equal percentages having to be obligated only as a default, the other part that House Bill 1375 does is that it says that if a municipality is going to use county property tax as far as for a project, that they have to also allow at least one person from on the URA board that's appointed by the county commissioners. So if the deal is all done with sales tax, then the counties don't get a person on there. They have no skin in that game as far as how that thing is being financed. But if you're using county property tax, then a person from their designee from the county would be allowed to be on that URA board as well. So that way they can actually see what's going on. There was a lot of concern that putting that one member on the board would actually cause a lot of trouble. Well, statutorily, as they stand right now, these are anywhere from 5 to 11 seat boards. Well, even at 5, adding one person on there is not going to roll the board. Definitely not at a max of 11. Most of these, when I was going through there, were anywhere from 9 to 11. One more person on the board isn't going to be able to shut down and log jam the entire process. We also heard that there might be some concern, or there could be some issue that, gosh, we won't be able to sell bonds because the folks coming in there or developers won't want to deal with multiple entities. Well, as it stands now, you're only still going to be dealing with one entity, and that is that URA board. So regardless of who sits on there, it's still one entity that person is actually going to be dealing with. So it actually is a pretty simple bill when we come down to that. So those two things, that's all that does. And so I urge an aye vote on 1375.
Representative Lebsack.
Thank you, Madam Chair. And boy, with that amendment, I was trying my darndest to get to a yes vote. And now we just can't get there. It's unfortunate. Representative Holbert, Representative Foote, and I, in good faith, brought forward an amendment that would have brought some more yes votes. And now what we've done is hurt that process, and now I'm a no on the bill. So it is unfortunate. I tried to collaborate with my colleagues from both sides of the aisle, tried to do that with an amendment that would save the tool of economic development But now what we've done for Lakewood, for Aurora, for Thornton, for North Glen, cities all over the state now are going to be hurt by this bill if we pass it in its current form. And so I'm asking the members in the House to listen to your cities, listen to your chambers, the North Metro chambers out there in the lobby. North Metro chambers opposed. All the chambers around the state are opposed. The developers in this state are opposed. All of our cities are opposed. What are we doing here, members? Let's save economic development in this state and vote no on this bill.
Representative Sane.
Thank you, Madam Chair. In my discussions, I've got 3 cities that straddle 2 counties. And the way the bill is written now, that URA board would now have 2 representatives from the commissioners. And that's a few too much. So I will move Amendment L022 and ask that it be properly displayed. So members, what this amendment does essentially establishes that on an urban renewal project, if it's located in an area that covers more than 1 county, that the boards of the county commissioners of the affected counties must agree on the appointment. And I think this is a common sense amendment because we have probably a lot of cities in this predicament where they cover more than 1 county. And obviously most renewal or urban renewal projects are going to be in 1 county or the other most of the time. But just to make sure this is clear in the statute, I think this is a common sense amendment and I urge a yes vote.
Is there any further discussion on the amendment? Representative Lipscomb.
Thank you, Madam Chair, and hopefully I'm going to provide the prime sponsor in the House an opportunity to digest this amendment because I think it's a good one. The city of Thornton is primarily in Adams County, but there is a portion of Thornton in Weld County. And so to keep it fair, I think this is a good amendment. The bill states that there'll be 1 member on the Urban Renewal Authority designated from a county. This should be in the spirit of the bill, and so I urge a yes vote.
Is there any further discussion on the amendment? Mr. Minority Leader.
Thank you, Madam Chair. Yeah, I was just quickly kind of going through this amendment as well. The whole process is supposed to be for representation, not to logjam the process. That is the reason for the bill. But I think this also kind of highlights why we also need the bill, because there's so much concern that we might actually get multiple people on a board and actually have multiple representation on a board. Because right now, the counties can actually not even see what's going on the way the thing is set up. But I do understand that if you've got multiple counties on one board and they might have 2 separate interests on that board, that could potentially cause some problems. So, I guess I don't care. You know, if you want to put them on there, put them on there. If you don't, don't. I mean, I guess I won't take a position on that.
Is there any further discussion on this amendment? Seeing none, the question before us is the adoption of L022. Those in favor say aye. Aye. Those opposed say no. No. The amendment fails. Mr. Minority Leader.
Thank you, Madam Chair. I have a whole slew of amendments, so members, please bear with me here for a second. I move L009 and ask that it be displayed.
The amendment is properly before us. Please proceed.
Thank you, Madam Chair. So, members, right now, the way the statute reads is that you can only have a maximum of 11 people on the URA board. So we kept getting asked, well, what would happen if we've already got 11 people on there and now you're forced to put more people on there? Are we going to have to just kick people off, or how is that process going to work? So this is amending the statute in the bill that actually takes that from 11 to 13. So that actually moves that up so they can actually, in this case, we're going to add somebody from the county on there. The city's even going to be able to add one person on there to actually almost offset their vote. So truly there is only now 1 versus 12 if we get to this case, but still truly with the intent that we're not trying to let somebody get on there and potentially roll the board. We're just changing this from 11 to 13. It kind of makes it a little more fair. So I urge an aye vote on L009.
Is there any further discussion on the amendment? Representative Labuda. Seeing none, the question before us is the adoption of Amendment L009. Those in favor say aye. Aye. Those opposed say no. The amendment passes. Mr. Minority Leader.
Thank you, Madam Chair. I move L011.
Please proceed.
Thank you, Madam Chair. So, members, L011, there was some concern in committee that possibly a county representative that was on there might live in another municipality. So if you're on there and the URA is in one town, but the person from the county lives in another town, they might get on there and have some kind of a conflict of interest because they live in one town and they might be fighting for an interest of one town, but not have the best intentions for the URA where they're sitting. So this just says that they actually have to live within the, they have to live within where they have to live in the area where it's used, and so I urge an aye vote.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L011. Those in favor say aye. Aye. Those opposed say no. The amendment passes. Mr. Minority Leader.
Yes. Good.
Please proceed.
Thank you, Madam Chair. Members, there was also some concern in committee how this was actually being calculated. And so they were saying that somehow when we were going through at the end, how the taxes were actually being calculated and going by a percentage. And so this just changes that percentage to a ratio at the end when they're figuring out a payback to each of the municipalities. And I urge an aye vote on L013.
Mr. Minority Leader, could you please move the amendment?
Oh, I guess I move L013 and then ask for an aye vote.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L013. Those in favor say aye.
Aye.
Those opposed say no. The amendment passes. Mr. Minority Leader.
Thank you, Madam Chair. I move L014 and ask that it be displayed.
Please proceed.
Thank you, Madam Chair. There was also some concern. We were talking about municipalities up front. A lot of times they do a lot of upfront investment. And there was some concern that some of the upfront investment they might not get, be able to get credit for that when a municipality is making upfront investment. And so monies wasn't quite clear what we were meaning by that. So we're actually expanding on that and saying monies, infrastructure, and other investments. and then pays to, and then contributes to or invests in. So it kind of broadens that, so it actually brings a little bit more into what we're saying municipalities can actually get credit for up front.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L014. Those in favor say aye.
Aye.
Those opposed say no. The amendment passes. Mr. Minority Leader,
I urge an aye vote on 1375.
is there any further discussion on House Bill 1375?
Well, I guess so.
Mr. Minority Leader.
I didn't want to take everybody's time up because I have several amendments, and so if somebody else was wanting to talk, I was going to allow them to keep going, but I guess it's dinner time, so I will move L012 and ask it to be displayed.
Please proceed.
Thank you, Madam Chair. L012 is basically just a clarifying amendment talking about tax mill levies, and I urge an aye vote.
Is there any further discussion on the amendment? The question before us is the passage of Amendment L012. All those in favor say aye. Aye. All those opposed say no. The amendment passes. Mr. Minority Leader.
Thank you, Madam Chair. I move L015.
Please proceed.
Thank you, Madam Chair. This is another clarifying amendment as to where the commissioner must reside, and I urge an aye vote.
Is there any further discussion on Amendment L015? The question before us is the adoption of Amendment L015. All those in favor say aye.
Aye.
Those opposed say no. The amendment passes. Mr. Minority Leader.
Thank you, Madam Chair. I move L016.
Please proceed.
Thank you, Madam Chair. L016 basically brings some more clarity that nobody's going to have veto power over another public body. So I urge an aye vote on L016.
Is there any further discussion on the amendment? Seeing none, the question before us is the adoption of Amendment L016. Those in favor say aye.
Aye.
Those opposed say no. The amendment passes. Mr. Minority Leader.
Thank you, Madam Chair. So members, I hope that you will see just with that slew of things there that we actually asked for an extra day from where this was heard in committee. It was going to be brought up on the floor yesterday. I asked to get another day in. So I've been trying to reach out and work with all parties that are involved to try to address as many concerns as possible. The goal here is not to shut down, as Representative Foote talked about, economic activity here in Colorado. It's to try to bring a little bit more fairness in the process between cities and counties. And any of the small concerns that we were hearing from some of those folks, I mean, obviously they had larger concerns of not liking the bill, but overall small concerns from whether folks that are selling bonds or however that works, trying to address some of their concerns, trying not to actually saying we're going to shut down this process. So again, I urge an aye vote on 1375.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill. Is the passage of House Bill 1375. All those in favor say aye. Aye. Those opposed say no. No. House Bill 1375 passes. Madam Majority Leader.
Thank you, Madam Chair. I ask for just a brief recess.
The House will take a brief recess.
Yeah.
Committee will come back to order. Mr. Kohler, please read the title of House Bill 168.
Senate Bill 168 by Senator Lambert, also Representative May, concerning the salary structure for compensating teachers employed by the Colorado School for the Deaf and the Blind.
Representative May.
Thank you, Madam Chair. I move Senate Bill 14168, and there's no committee report.
To the bill.
Members, what this bill does is allow for teachers at the deaf and blind school to be able to move within the range when they're hiring. Right now they have a difficult time in keeping talented teachers or hiring teachers for the area of expertise that they need because they're locked into the policies. So it's a happy bill. It's not a controversial bill. I ask for a yes vote. Thank you.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 168. All those in favor say aye. Aye. Those opposed say no. House Bill 168 passes. Mr. Kohler, please read the title of Senate Bill 183.
Senate Bill 183 by Senators Heath and Sheffield, also Representatives Pabon and Holbert, concerning increase in the maximum term of business incentive agreement that a local...
Madam Majority Leader.
Oh, can we? Oh, there you are. Okay, I take it back.
That a local government enters into with a taxpayer who pays business personal property tax.
Representative Holbert.
Thank you, Madam Chair. For my last time as a member of this chamber, I move Senate Bill 183, and there is no committee report.
To the bill, Representative Holbert.
Thank you, Madam Chair. Senate Bill 183 proposes one simple change in business incentive agreements for local government jurisdictions. And that is that right now in statute, when they enter into a BIA, there's a requirement that the term of that BIA be no more than 10 years. Senate Bill 183 allows greater flexibility in that those local jurisdictions can negotiate BIA agreements to a term of 35 years. There's no requirement that they extend those terms, but it does allow those local jurisdictions greater flexibility when negotiating a BIA. This is one of the tools that our local governments have, because in Colorado we don't have money to attract businesses into our communities. So what can we do to allow special districts, municipalities, and counties to negotiate more aggressively to bring companies into our jurisdictions, bring jobs into our jurisdictions? This is one way that we can then empower those local jurisdictions to do that. Earlier I spoke about Douglas County being able to bring companies into our county. We have brought companies, jobs into Douglas County, and many people have asked, how do you do that? One of the incentives is the approval of 100% negotiation on locally assessed business personal property tax that the General Assembly approved almost unanimously. This is another small change that we can make to empower our local jurisdictions, again, special districts, municipalities, and counties, to negotiate to bring companies and jobs into those jurisdictions. I ask for an aye vote.
Is there any further discussion? Representative Pabon.
Thank you, Madam Chair, and Representative Holbert. I echo his comments and want to make it clear that this was a large bipartisan effort in the Senate with a 34-to-1 vote, and this is not a Democratic solution or Republican solution to better economic development and better flexibility. This is a Colorado solution. Ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 183. All those in favor say aye. Aye. Those opposed say no. Senate Bill 183 passes. Mr. Kohler, please read the title of Senate Bill 171.
Senate Bill 171 by Senators Schwartz and Jones, also Representative Tyler, concerning the ability of the Colorado New Energy Improvement District to arrange financing for water conservation fixtures.
Representative Tyler.
Thank you, Madam Chair. I move Senate Bill 171 to the committee. No, that's us. I move Senate Bill 171. There is no committee report.
To the bill.
Thank you, Madam Chair. This is a simple fix for something we passed last year, which allows businesses to provide get better financing for their energy efficiency improvements. And when we ran the bill last year, we inexplicably left off water as something they could make improvements on for efficiency, and this just simply adds water. There are no opponents to this bill. I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 171. All those in favor say aye. Aye. Those opposed say no. Senate Bill 171 passes. Mr. Kohler, please read the title of Senate Bill 152.
Senate Bill 152 by Senator John, also Representative Milton, concerning the standardization of financial transaction requirements applicable to insurers.
Mr. Milton.
I move Senate Bill 152. There's no committee report and ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 152. All those in favor say aye. Aye. Those opposed say no. No. Senate Bill 152 passes.
Tied. No, what? Tied?
Mr. Kohler, please read the title of Senate Bill 173.
Senate Bill 173 by Senators John and King, also Representative Singer and McNulty, concerning the recommendation that certain persons be offered a test for the hepatitis C virus.
Representative Singer.
Thank you, Madam Chair. I move Senate Bill 173.
Are there any committee reports?
No.
To the bill.
Thank you, Madam Chair. At this late hour, I move Senate Bill 173.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 173. All those in favor say aye. Those opposed say no. Senate Bill 173 passes. Mr. Kohler, please read the title to Senate Bill 125? No.
What?
Madam Majority Leader, we'll take a brief recess. Madam Majority Leader.
You're rounding.
Thank you, Madam Chair. I move to lay over Senate Bill 125, 3 bills.
The Senate Bill 125 will be laid over as requested by the Majority Leader. Mr. Kohler, please read the title of Senate Bill 011.
Oh, sorry. Senate Bill 11 by Senator Heath, also Representative Hollinghorst, concerning the Colorado Energy Research Authority in connection with making and reducing appropriations.
Madam Majority Leader.
Thank you, Madam Chair. I move Senate Bill 11, the Transportation and Energy Committee report, and the Appropriations Committee report.
To the Appropriations Committee report.
Thank you, Madam Chair. This confirmed a appropriation for this bill and had it go into the general fund. I ask for a yes vote.
Thank you, Madam Chair. Is there any further discussion? Seeing none, the question before us is the adoption of the Appropriations Committee report. All those in favor say aye. Aye. Those opposed say no. The Appropriations Committee report is passed. Madam Majority Leader.
Thank you, Madam Chair. To the Transportation and Energy Committee report. This was a technical amendment that defined the transfer relative to the appropriations. I ask for a yes vote.
Is there any further objection? Seeing none, the question before us is the passage of the Transportation and Energy Committee report. All those in favor say aye. Those opposed say no. The committee report passes. To the bill, Madam Chair.
Thank you,
Madam Majority Leader.
Thank you, Madam Chair. This bill refunds the Colorado Energy Research Collaboratory. It's a very important program that we have in the state of Colorado that provides a partnership among the National Renewable Energy Laboratory and Colorado's premier research universities, Colorado School of Mines, Colorado State University, and the University of Colorado. And the collaboratory works with industry, public agencies, and other universities to do research in clean energy technologies for rapid transfer to the marketplace, to support economic growth with clean energy industries, and to educate the finest energy research technicians and workforce in the country, if not the world. It has a great cost-benefit ratio for the $6 million that was put into this program over the last 5 years or so. About $50.6 million actually was generated, and a lot of wonderful research projects. I ask for a yes vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 11. All those in favor say aye.
Aye.
Those opposed say no. Senate Bill 11 passes. Mr. Kohler, please read the title to Senate Bill 15.
Senate Bill 15 by Senator Kerr, House of Representatives Young and Melton, concerning the creation of a hospitality career grant program in connection with making and reducing appropriations.
Representative Young.
Thank you, Madam Chair. I move Senate Bill 15 and the report from the Appropriations Committee.
To the Appropriations Committee report. Mr. Representative Young.
Thank you, Madam Chair. The Appropriations Committee made minor modifications, technical changes to the Appropriations Clause. I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the adoption of the Appropriations Committee report. Those in favor say aye.
Aye.
Those opposed say no. The Appropriations Committee report passes. Representative Melton.
Thank you, Madam Chair. And members, I ask for an aye vote on Senate Bill 15. This is a great education training bill that helps our high school students make that pathway to career a lot easier in some of our most important fields, hospitality and culinary and restaurant management. This is a... Why were you looking at me? Oh, I'm being told to wrap it up. So I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 15. All those in favor say aye. Those opposed say no. Senate Bill 15 passes. Mr. Kohler, please read the title to Senate Bill 151.
Senate Bill 151 by Senator Talktrop, also Representative Young, concerning the use of monies derived from civil penalties imposed on nursing facilities to fund innovations in nursing home care in connection with making appropriation.
Representative Young.
Thank you, Madam Chair. I move Senate Bill 151. There is no committee reports.
To the bill.
Thank you, Madam Chair. Senate Bill 151 is an effort to actually improve the innovations in nursing homes and provide better person-centered care. I ask for your aye vote.
Representative, is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 151. All those in favor say aye.
Aye.
Those opposed say no. Senate Bill 151 passes. Madam Majority Leader.
Thank you, Madam Chair. I move to lay over Senate Bill 125 to below Senate Bill 75.
Senate Bill 125 will be laid over as requested by the Majority Leader. Mr. Kohler, please read the title of Senate Bill 64.
Senate Bill 64 by Senator Ulibarri, also Representative Salazar, concerning restricting the use of long-term isolated confinement for inmates with serious mental illness in connection with making and reducing appropriations.
Representative Salazar.
Thank you, Madam Chair. I move Senate Bill 64 and the Appropriations Committee report.
To the Appropriations Committee report.
Thank you, Madam Chair. The Appropriation Committee report basically changed the way that the funding structure would be done. It is now coming out of the general fund instead of out of the Controlled Maintenance Trust Fund, and I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the passage of the Appropriations Committee report. All those in favor say aye.
Aye.
Those opposed say no. The Appropriations Committee report passes. To the bill, Representative Salazar.
I ask for an aye vote on Senate Bill 64.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 64. All those in favor say aye. Aye. Those opposed say no. Senate Bill 64 is passed. Representative Kohler, please read the title to Senate Bill 130. I'm sorry. Mr. Kohler, please read the title of Senate Bill 130.
I'll take it. Senate Bill 130 by Senator Tocktrop, also Representative Primavera, concerning increase of the personal needs allowance for persons in nursing care facilities in connection with making and reducing appropriations.
Representative Primavera.
Thank you, Madam Chair. I move Senate Bill 130. There is no committee report.
To the bill.
What Senate Bill 130 does is it takes personal needs allowance, raises it from $50 a month to $75 a month, beginning on January 1st, and then will increase each year by the same percentage as the nursing facility provider reimbursement rate goes up. Personal needs allowance was enacted in 1987. At that time, it was $30 a month. This is used for people in nursing facilities and regional care, the regional centers, for things like clothing, other goods, gifts for grandkids, and that kind of thing. We changed it in 1999, increased it from $34 to $50. It impacts people on Medicaid in nursing facilities and people with developmental disabilities in regional centers. I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 130. All those in favor say aye. Those opposed say no. Senate Bill 130 passes. Mr. Kohler, please read the title of Senate Bill 144.
Senate Bill 144 by Senators Aguilar and Nicholson, also Representative Janal, concerning extending the Commission on Family Medicine support for the development of family medicine residency programs in underserved areas of the state in connection with making and reducing appropriations.
Representative Janal.
Madam Chair, I move Senate Bill 144.
To the bill.
Senate Bill 144 is a bill that is a health care bill, but it's also a rural health care bill. And I ask you to support this bill, which helps our rural communities in regards to the health care needs for primary care physicians. It increases the rural slots and sustains the rural residency slots that are already set up. It supports the study of family practice residency programs and how these programs will meet the primary care workforce needs in rural and underserved areas of Colorado in the future. I ask for a yes vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 144. All those in favor say aye. Those opposed say no. Senate Bill 144 passes. Mr. Kohler, please read the title to Senate Bill 157.
Senate Bill 157 by Senators Carroll and Cadman, also Representatives Ryden and Nordberg, concerning the Commissioner report by the Department of Military and Veterans Affairs that examines the comprehensive value of United States military activities centered in Colorado in connection with making and reducing appropriations.
Representative Ryden.
Thank you, Madam Chair. I move Senate Bill 157.
Is there a committee report?
And there is no committee report.
To the bill.
Thank you, Madam Chair. Members, as you all know, we have a very strong military and defense presence in our state, and it brings a lot of value to our economy. And we're currently planning for the next round of base realignment commission reports, which would come in 2 or 3 years, and we want to be prepared for that. So what we want to do is commission a report that would give us a third-party objective report of all of our assets and resources, as well as the challenges we might face, so that we can let our folks in Colorado know what our capabilities are, and then also we want to let the folks in Washington know that we're here, we're ready to accept new commands and new operations in Colorado, and we need this report to be able to show them that that's the fact. I urge a yes vote on
Representative
Senate Bill
Nordberg.
157.
Thank you, Madam Chair and members. Over the next 10 years, there's going to be $1 trillion or close to $1 trillion in defense spending cuts. We know there's going to be a force reduction as a result of that. We know there's going to be another base realignment and closure process as a result of that. But the steps that we take today can really help mitigate any of the negative impacts in the future. And we really need not to look further than the last BRAC process. The states that had factual data, neutral factual data, to provide to the Department of Defense in support of their military missions fared much better than those who did not. So this is a great step in that process. We have a great opportunity moving forward to not only protect our bases, but also grow them and grow further missions. I'd ask for a yes vote.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 157. All those in favor say aye.
Aye.
Those opposed say no. Senate Bill 157 passes. Mr. Kohler, please read the title to Senate Bill 75.
Senate Bill 75 by Senator Baumgartner, also Representative Sonnenberg, concerning the registration of motor vehicles for members of the United States Armed Forces who are deployed outside the United States in connection with making and reducing appropriations.
Representative Sonnenberg.
Move Senate Bill 75.
Is there any further discussion? Seeing none, the question before us is the passage of Senate Bill 75. All those in favor say aye. Those opposed say no. Senate Bill 75 passes. Madam Majority Leader.
Thank you, Madam Chair. May we have a brief recess?
Did we beat the record? Oh, I'm sorry. The House will go into a brief recess.
The House will come to order. Madam Majority Leader.
Thank you, Madam Chair. I move that the committee rise and report progress and beg leave to sit again later.
Seeing no objection, the House will rise and report.
And beg leave to sit again.
And beg leave to sit again.
The House will come back to order. Mr. Kohler, please read the report of the Committee of the Whole.
Mr. Speaker, Committee of the Whole reports as follows. As risen, reports progress and begs leave to sit again later in the day.
Sounds great. Reports of committees of reference.
The Committee on Legislative Council, after consideration on the Mayor's Committee recommends the following. House Bill 1343 be amended as follows and as so amended be referred to the Committee of the Whole for recommendation. House Bill 1377 be amended as follows and as so amended be referred to the Committee of the Whole for recommendation. Senate Bill 21 be referred favorably to the Committee on Appropriations. Senate Bill 88 be amended as follows and as so amended be referred to the Committee on Appropriations in favor of recommendation. Senate Bill 50 be amended as follows and as so amended be referred to the Committee on Appropriations in favor of recommendation. Senate Bill 115 be amended as follows and as so amended be referred to the Committee on Appropriations in favor of recommendation. Senate Bill 153 be amended as follows and as so amended be referred to the Committee on Appropriations in favor of recommendation.
Is that it, Mr. Kohler?
Yes, sir.
Printing report.
Chief Clerk,
Remainder of the printing board, printed journal. Message from the body that should be known as McNulty.
Mr. Speaker, the body that should be known as McNulty has
The remainder of
adopted.
the message from that body will be printed in the journal. Message from the reviser.
We hereby transmit without
Remainder of
comment.
the message from the reviser will be printed in the journal. Message from the governor.
Ladies and gentlemen, I have the honor
Remainder
to
of the message from the governor will be printed in the journal. Introduction of bills.
House Bill 1393 by Representative Giroux, also Senator Hodge, concerning clarification regarding the treatment of federal funds for purposes of Section 20 of Article 10 of the State Constitution.
House Bill 1393 assigned to the Committee on Finance.
House Bill 1394 by Representative Duran, also Senator Lambert, concerning the use of disputed payments of tobacco litigation settlement monies received by the state to reduce the annual amount of accelerated payments allocated from the tobacco litigation settlement cash fund.
House Bill 1394 assigned to the Committee on Appropriations.
Senate Bill 188 by Senators Schwartz and Baumgartner, also Representatives Fisher and Rankin, concerning measures to effectuate the conservation of native species in Colorado in connection with making appropriations from the Species Conservation Trust Fund for purposes recommended by the Department of Natural Resources.
Senate Bill 188 assigned to the Committee on Agriculture, Livestock, and Natural Resources.
Senate Bill 194 by Senator Stebbins, also Representatives May and Giroux, concerning the issuance of identification documents by the Department of Revenue in connection with making an appropriation.
Senate Bill 194 assigned to the Committee on Appropriations. We got 3 more coming, Mr. Kohler. 6 more. 7. Some number more.
House Bill 1395 by Representative Giroux, also Senator Lambert, concerning information technology budget requests in connection with moving the review and prioritization of information technology budget requests previously requested as capital construction to Joint Technology Committee, establishing specific deadlines for information technology budget requests and making an appropriation.
House Bill 1395 assigned to the Committee on State, Veterans, and Military Affairs.
House Bill 1396 by Representative Wright and also Senator King, concerning clarification of the authority of persons acting on behalf of the Department of Public Health and Environment to administer the medical marijuana registry.
House Bill 1396 assigned to the Committee on State, Veterans, and Military Affairs.
Senate Bill 3 by Senator Nicholson, also Representative Pedersen, concerning child care assistance for working families in connection with making an appropriation.
Senate Bill 3 assigned to the Committee on Health, Insurance, and Environment.
Senate Bill 164 by Senators Carroll and King, also Representatives Gardner and McLaughlin, concerning aerial firefighting efforts through the Division of Fire Prevention and Control in the Department of Public Safety in connection with implementing recommendations made by the Division regarding the Colorado Firefighting Air Corps.
Senate Bill 164 assigned to the Committee on Agriculture, Livestock, and Natural Resources.
Senate Bill 176 by Senator Johnston, also Representatives Murray and Court, concerning crimes related to entities that trade in stolen vehicles in connection with making an appropriation.
Senate Bill 176 assigned to the Committee on Judiciary.
Senate Bill 187 by Senators Aguilar and Roberts, also Representatives Stevens and Schaefer, concerning creation of the Colorado Commission on Affordable Health Care to analyze health care costs in Colorado in connection with making an appropriation.
Senate Bill 187 assigned to the Committee on Health, Insurance, and Environment. Introduction of resolutions.
Senate Joint Resolution 37 by Senators Grantham and Schwartz, also Representatives Wilson and Garcia, concerning the designation of May 4th through 10th, 2014 as National Correctional Officers Employees Week.
Senate Joint Resolution 37 will lay over 1 day under the rules. Anything else, Mr. Kohler?
No, sir.
Okay. We're good reading. Where is Representative Becker? Representative Becker. You move that we? Final orders, special orders. There we go. You heard the motion. Seeing no objection, the House resolves itself in the Committee of the Whole for continuation of special orders. Representative Becker will take the chair.
Committee will come to order. With your unanimous consent, the bills will be read by title unless there's a request for reading a bill at length. Committee amendments will not be read unless requested as they're printed and in your bill folders. Floor amendments will be shown on the screen and not read unless requested. Bills will be laid over upon motion of the majority leader, and the coat rule is relaxed. Mr. Kohler, please read the title of Senate Bill 125.
Senate Bill 125 by Senators John and Harvey, also Representatives Pabon and Szabo, concerning the regulation of transportation network companies in connection with requiring transportation network companies to carry liability insurance, conduct background checks on transportation network company drivers, inspect transportation network company vehicles, and obtain a permit from the Public Utilities Commission, and making an appropriation.
Mr. Assistant Majority Leader.
Thank you, Madam Chair. Madam Chair, I move Senate Bill 125, the Appropriations Committee report, and the Transportation and Energy Committee report.
To the Appropriations Committee report.
Thank you, Madam Chair. In the Appropriations Committee report, this simply transfers the monies that are collected from the transportation network companies and grants that to the PUC for oversight of these companies. Ask for an aye vote.
Is there any further discussion on the Appropriations Committee report? Seeing none, the question before us is the passage of the Appropriations Committee report. All in favor say aye. Those opposed say no. The Appropriations Committee report passes. Representative Pabon.
Thank you, Madam Chair. The Transportation and Energy Committee report is a 6-page committee report, and I've got to give credit to the members of the House Transportation Committee for taking this bill so seriously and making sure that the public safety is protected, the consumers are protected, the people of Colorado are protected, and of course the new companies have the ability to still live and thrive in the state of Colorado. I asked for a yes vote on the committee report. There are several amendments to the committee report, and I don't know if before we start amending it, the chair of the committee report would like to.
Representative Pabon, did you move the committee report?
I did,
Okay.
when I first moved the bill. And
Okay, thank you. Representative Tyler.
Thank you, Madam Chair. Members and committee, you know, the Transportation Committee really did good work on this. We had a number of amendments. If you remember the 14 hours we spent on it by chance, we had a number of amendments that passed with very strong bipartisan support. We had some amendments that were rejected with strong bipartisan support. And I think overall, I must say, I think we did really good work on this bill. And as I look at what the amendments coming forward, and we've had a lot of very interesting discussions this evening, I think we're going to end up with a bill that is probably a real classic case of what happens in the legislative process. This is going to be a bill that everybody's a little bit grumpy about, maybe in some cases a lot grumpy about, but we did make some significant progress, and I think the bill that we're coming up with out of this is really a positive bill that goes a long way toward ensuring public safety for this new means of transportation. I will say also that I would urge you to vote your conscience on this. Perhaps it could have gone further in terms of public safety, but I think this is the bill that we need to pass to make sure that we have as much as we can for public safety and also allow this new transportation methods to continue working in Colorado with pretty good guardrails around it. We will have a couple of amendments coming forward, but members, thank you for all your hard work, and I want to thank the Governor's Office. We tried, the Transportation Committee and myself worked very closely with the Governor's Office and tried to stay very closely in tune with them and what they were looking for to make sure that we would have something that would get the 33, 18, and 1 votes that need to pass. So let's continue from there. Thank you.
Representative Pabon.
Thank you, Madam Chair. Madam Chair, I move L089. It is a multi-page amendment that was distributed yesterday at 5:54 p.m.
Please proceed.
We did meet the 24-hour rule. In case anyone was wondering, which is why we needed the extra delays, so we complied with the rules.
Are we good?
Please proceed.
Should I give you a little background?
Representative Zabo.
Oh, yeah, never mind. Never mind, give it to him.
Representative Pabon.
Thank you, Madam Chair and members. This is, again, a multi-page, 1, 2, 3, 4, 5 pages. And as you might imagine, there has been a lot of discussions about the insurance associated with this bill. Raise your hand if you've heard about insurance associated with Senate Bill 125. Okay, you're not all raising your hands, but I know all of you have heard about this issue. And we wanted to make sure that the consumers of the state of Colorado were properly protected. And so what this does is it says within 90 days of the effective date of this bill that there will be $1 coverage, primary coverage, during the prearranged ride, which is the time for all of you who have not used these applications, is the time when a driver accepts a ride, is en route to the rider, picks up the rider, and drops the rider off. There will be a $1 million commercial primary liability policy. That's a good thing, and that was a lot of work to get here. I want to thank those who were willing to do that. And then this also says that effective, and we have some amendments to this as well, and we'll move those here shortly, that as of, well, we'll wait until we move to the amendments. And then there is also a recognition that after date certain, which will change in a moment, there will be 3 types of coverage that will be able to be met. One is that a driver or a transportation network company could obtain, and that is the minimum requirements set forth in the Motor Vehicle Financial Act, and is full-time coverage associated with taxi cabs, a rider to the coverage, or a commercial liability policy. And there will be some changes to that. Long story short, there's also provisions in here that require that there is an effort to help a disabled member of our community with their equipment, which is common sense, but we wanted to put that in the statute. It also defines under our anti-discrimination clause and statutory requirements, we use some of the definitions that are contained in current law. There is discussion about the enforcement of violation of the disability clause, and then basically giving the PUC authority, the Colorado Department of Labor and Employment authority to promulgate rules regarding workers' compensation. Many of these requests were made by our friends, stakeholders as part of this process, the AFL-CIO, the CWA, the taxi cab companies, the limo companies. There are many stakeholders associated with this. So this is a pretty comprehensive amendment. And now we're going to move on to the amendments to this amendment. But I do ask for an aye vote on this amendment once it's been amended.
Is there any further discussion? Seeing none, the question before us is the, Representative Williams.
Thank you, Madam Chair. And members, we have been discussing insurance, and so I would ask that L102 be displayed. That is a motion to move L0102 and to ask for it to properly be displayed. So members, there's been a lot of conversation today in regards to the insurance of when the app is off. And when the app is off, the personal policy of that driver is what will be the coverage. And because I've been in this business for 14 years, I've seen losses, I understand liability, and we want to make sure that we are operating in the best interest at this time for the people of Colorado and the best interest of public safety. And so through this, we have all come to an agreement, myself, the sponsors, the chair of the Transportation Committee, and the business industry, and other stakeholders. So what L102 does is that it moves the effective date up from May the 1st of 2015 to January the 15th of 2015. What this also does is that the minimum limits that are required by state law is 25, 50, 15. What this amendment will do is that it will double that coverage, and that will be 50, 100, 30. So it will increase that coverage. It basically doubles the coverage for the use of the motor vehicle at that time. And in case you're not familiar or you haven't gone home and looked at your policies lately, the 50 stands for the coverage per accident, one person in any accident. The $100,000 stands for per occurrence. So if there were 3 people in an accident, the maximum that it'll pay out is $100,000. And then the $30,000 covers the physical damage to a vehicle. That's the way all your policies work now, no matter what the limits are. The third part of this amendment requests a study in which the Division of Insurance will perform the study to determine if the levels in this amendment are the proper limits for this type of risk. When the study is complete, which we've asked for January the 15th of 2015, it will report back to the Business, Labor, Economic Development Committee in the House and in the Senate, and the Transportation Committee in the House and the Senate. We feel like this is important, again, to ensure that we have proper protections, and I ask you for an aye vote on L102.
Representative Szabo.
Thank you, Madam Chair, and thank you, Representative Williams, for bringing this. And this has been a long negotiation to get this amendment, and I'm just glad that we all could work together, get the safety precautions and the things that we need for the citizens of the state to be safe, and for this new innovative way of transporting people from point A to B to keep them working and in business. I ask for an aye vote.
Is there any further discussion? Seeing none, the question before us is the adoption of Amendment L102. All those in favor say aye. Aye. Those opposed say no. The amendment passes. Representative Tyler. I'm sorry, to the amendment? Yes.
Right. Thank you, Madam Chair. We are in the main amendment, and I want to make a couple points. There are a couple other amendments coming, as I understand. If you read this amendment, I actually had my aide spend about 4 hours today sort of merging the two amendments and see what they look like. But we had some good amendments in the Transportation Committee that have been incorporated in this in the currently standing amendment. One of them on discrimination, which there will be an amendment to make it even better in a little bit, and one of them on workers' comp, and there will be an amendment to bring that forward also. So some of this is cleanup, making what we did in the Transportation Committee a little bit better. Some of it is areas that I think improve the bill overall. Some of it's stuff that I would like to see better, frankly. I think what we're missing in here is the concept that a car needs to have a certified mechanic inspection before it goes on the road. That's what limos have to do and such like that. But as I said before, we don't all get what we want, but we get what we need. And I would urge an aye vote on this amendment. And let's move this forward. Thank you.
Is there any further discussion on Amendment L089? Representative McCann.
Thank you, Madam Chair. My only concern about this is that it doesn't require the company to actually purchase the insurance. It says in all the references that it's the transportation network company or the driver. So it seems to me that the company can simply say, we're not going to provide this insurance. If you want to work for us, you have to purchase it yourself, which seems a little bit inconsistent with the idea of the company reaping the benefit of these drivers, and also seems inconsistent with the way that taxis work, where the company actually purchases the insurance. There's nothing in this amendment that requires the company to purchase the insurance. It requires that the insurance be purchased by either the company or the driver. So I'm concerned about that. I think the company should be required to provide the insurance.
Representative Pabon.
Thank you, Madam Chair, and Representative McCann. I appreciate your comments on that. Just briefly, right now, as a practical matter for the companies that are in business right now, the company does indeed purchase these policies, but we have to think about the subsequent companies as well, and their business model, may be a co-op of a sort. Keep in mind that taxi companies under our committee report can convert to TNCs, and for instance, Union Taxi has a co-op, so it would technically be the driver really more purchasing the policy than the company. So this just gives maximum flexibility to the model, and so that's why we have that. But with that, I would move L093 and ask that it be displayed.
Please proceed.
Thank you, Madam Chair. This is an amendment that deals with makes it very clear where the delineation occurs for discrimination, and basically says that when a rider and a driver have been paired, and they refuse that rider based on discriminatory reasons, that's an actionable offense and is dealt with appropriately via civil penalties and other penalties. But we wanted to make that clear because, again, this is technology recognition of how this works. And then line 5 deals with the Colorado Department of Labor and Employment putting rulemaking in place for workers' comp. And this is basically saying that upon effective date that the CDLE will begin to work on that. So ask for an aye vote.
Is there any further discussion on Amendment 093? Seeing none, all those the question before us is the adoption of L093. Those in favor say aye. Aye. Those opposed say no. The amendment passes. Representative Pabon.
Thank you, Madam Chair. I move L095 and ask that it be displayed.
Please proceed.
Thank you, Madam Chair. L095 simply makes what was a cumbersome provision in the L089 with respect to TNC liability more clear, and gives some recognition that the drivers will have to report these discriminatory acts, and that those acts will then be required to be reported to the PUC so they can monitor it accordingly, and ask for an aye vote.
Is there any further discussion on Amendment L095? Seeing none, the question before us is the adoption of L095. All those in favor say aye. Those opposed say no. L095 passes. Representative Pabon.
Thank you, Madam Chair. With that, I would ask that we pass the Pabon, Zabo, Lawrence, Wright, and Ferrandino Amendment L089.
Is there any further discussion on Amendment L089? Seeing none, the question before us is the passage of L089. All those in favor say aye. Aye. Those opposed say no. L089 passes. Representative.
Bill, right?
To the bill.
Oh, we're on the committee report.
You can talk about that.
Rep-
talk about the bill.
Representative Pabon.
Thank you, Madam Chair. With that, I ask for a yes vote on the Transportation Committee report.
Is there any further discussion on the Transportation Committee report? Seeing none, the question before us is the passage of the Transportation Committee report. All those in favor say aye. Aye. Those opposed say no. The Transportation Committee report passes. To the bill. Representative Zabo.
Thank you, Madam Chair, and we'll just make this quick because we've been here a long time, but I just would like to say that UberX and Lyft is a great way to help you in your day-to-day solution from getting to point A to point B. A lot of you here have used it. It's the young people really love it. That's how I learned about it, from my daughter. And it's a great business model that is coming in to our state, and it is widely used. And I think it's only going to grow from here, and this is a huge work in progress, and I thank everybody who helped out on it, who listened to all the different mechanisms that have come in and out, and all the types of issues that have come. I know it's been a tough one, but I think we're finally there, and I would ask for an aye vote on Senate Bill 125.
Is there any further discussion on Senate Bill 125? Representative Pabon.
Thank you, Madam Chair. Members, history is being made right now. We will be one of the first in the West, one of the first in the Midwest, and one of the first in the country to regulate these companies, TNCs. This is Uber and Lyft today, but this is not the end. This is only the beginning. And to welcome them to Colorado as a transportation option when other transportation options might not be available, might not be affordable, might not be practical. This is an option that will help us relieve the congestion in places like US 36, I-70, and beyond. And I know that all of you have challenges in each of your districts, no matter rural or urban, no matter big or small. This is a solution that is available and should be coming to a place near you. So we want to make sure that we protect the public safety, we protect the consumers, we do what's right by the people of Colorado, and we make sure that they have a safe, affordable, and wonderful way to travel in the state. I ask for an aye vote.
Is there any further discussion? If not, but the question before us is the passage of Senate Bill 125. All those in favor say aye. Aye. Those opposed say no. Senate Bill 125 passes. Madam Majority Leader.
Thank you, Madam Chair. I move the committee rise and report.
There's no objection. Seeing no objection, I move that the House rise and report.
The House will come back to order. Mr. Kohler, please read the report of the Committee of the Whole.
Mr. Speaker, Committee.
With the mic on, please.
Yes, sir. Mr. Speaker, Committee of the Whole begs leave to report under consideration the following attached bills being second reading thereof and makes following recommendations thereon. House Bills 1374 amended, 1375 amended, 1378 amended, 1379, 1386, 1388, 1390 passed on second reading or gross placed on counter for third and final passage. Senate Bills 11 amended, 15 amended, 64 amended, 75, 125 amended, 130, 144, 151, 152, 157, 168, 171, 173, 183 passed on second reading in order revised placed on counter for third and final passage.
Representative Becker. You've somewhat heard the motion that the House now adopt the report of the Committee of the Whole. That would be the motion. There are several amendments at the desk. Mr. Kohler, please read the Lebsack amendment to the report of the Committee of the Whole.
Representative Lebsack moved to amend the report of the Committee to hold adverse action taken by the committee in not adopting the following Foote, Lebsack, and Holbert Amendment L020 to House Bill 1375 to show that said amendment passed and that House Bill 1375 as amended passed.
Representative Lebsack.
Thank you, Mr. Speaker. I move the Lebsack amendment to the Committee of the Whole and ask for a yes vote.
To the amendment, Representative Lebsack. It is displayed. It's okay. Ron knows everything.
Now that the amendment is properly displayed, ladies and gentlemen, members, if you're for economic development, vote yes on this amendment. If you're for job growth, vote yes on this amendment. I've got a list of cities who use urban renewal. Some of these cities, in fact, most of them, have taken positions on this bill and are opposed to the bill. These cities here use urban renewal, and this bill, without this amendment, is going to be negatively affecting these cities. La Junta, Fountain, Pueblo, Colorado Springs, Manitou Springs, Parker, Littleton, Sheridan, Aurora, Denver, Lakewood, Thornton, North Glen, Westminster, Golden, Longmont, Fort Collins, Loveland, Greeley, Sterling, Dillon, Silverthorne. I mean, the list goes on and on. Firestone, Brighton, Lafayette, Commerce City.
So keep going.
Superior. I mean, we can go on and on. Many of these cities have taken official position opposing the bill. So what I did was I tried to work with both sides to come up with a compromise. The amendment specifically states that counties can appoint someone to the table. Counties will have someone at the table when urban renewal authorities do their work now, if we vote yes on this amendment. We need a yes vote to make sure that not only will counties have a seat at the table, but we'll also have an opportunity over the next year to properly study this. The prime sponsor in the House had 6 or 7 amendments that we did. This wasn't ready for prime time, and it's still not. Let's look at this and make it fair for counties, fair for cities. Make sure that we have economic development and job growth. Make sure this body is doing the right thing. I ask for a yes vote on the Lebsack amendment to the Committee of the Whole.
Representative Rosenthal.
Thank you, Mr. Speaker. I also rise in support of this amendment to the Committee of the Whole report. Members, this bill, as it currently stands, is a kick in the gut to local government, and local government's development. We elect local government officials for a purpose, and that is to represent our areas and our cities. And I know that there was some discussion whether this applies to Denver or does not. It does apply to Denver. The part about having a, quote, seat at the table for counties is correct. That part does exempt city and counties. However, the tax formula does apply to Denver. So if this bill passes, there are projects in Denver that would still need to negotiate with all property tax entities, including the Urban and Drainage, Denver Public Schools, and several others, depending on what part of the city you're in. For example, the project at 9th in Colorado, the CU Hospital project, that might be put in jeopardy. The downtown Denver, there are 16 separate TIF areas. Brighton Boulevard, Sun Valley. And the reason why is because in order to get that 100% property tax for the TIF, you need 100% of the sales tax, which Denver would not be able to do because 0.12% is earmarked for ECE. And when you look at large projects, they need every penny they can get for these large projects. So I ask members, please support this amendment so we could continue to make sure that we have TIF projects approved by the people who are best able to do so, and that is our local governments. Thank you.
Representative Schaefer.
Thank you, Mr. Speaker. I ask for a yes vote on the Lebsack amendment to the Committee of the Whole. Members, I'm sorry for the conflicts that have arisen among the counties and the cities and the special districts. I wish we could all, benefit, have a win-win here. But I have heard from all of my mayors in Jefferson County asking for a defeat on 1375, but I think this amendment here is a good compromise since we're all so divided on this, why not take another year and try to get it right? I'm joining the cities that Representative Lebsack mentioned. I'm speaking for Arvada, for Lakewood, for Wheat Ridge, and for Golden, our inner city, our inner urban ring of cities need this TIF. Let me give you an example from Golden, Colorado. Maybe you had been out to Golden about 15 years ago and you saw a dusty road with a failing downtown business district. This TIF encouraged Golden to be able to rebuild its infrastructure, to rebuild its cities, its roads, and its business district. And when you go out there now, you just see a very thriving western town in the inner ring suburb of Golden. My city of Wheat Ridge is in the same boat. We are having very slow growth, but we need a TIF just to give us a little extra boost. Now, we have heard that it's not fair to special districts and school districts. Members, the last I checked, we have already allocated $500 million more to our school districts. Many of our fire districts are going to likely win mill levies to help them. So please, let's give our some more consideration so we can all agree. And I ask for your support on the Lebsack amendment. Give us a chance to think about this before we do something that's not the right thing. Thank you.
Representative Duran.
Thank you, Madam Chair, and I do rise in support of this amendment as well. Earlier, it was characterized that some of these tools are used by local governments for corporate welfare and taking money away from schools, and I can't disagree with that more. And the reason why is that when you actually look at how some of these tools have been used, they've been used very effectively to actually help local schools. Beyond that, though, there was also a question about whether or not this applies to the City and County of Denver, and I agree with Representative Rosenthal that it absolutely does. And specifically, there's still vagueness in this bill. And if you look at page 5, lines 9 and 10, there's a lot of questions around how a municipal sales tax revenue is going to be defined. In the City and County of Denver, we have several different sales tax that vary across the board. And so it is vague still. This bill is not ready for prime time. We saw the minority leader introduce and have 7 different amendments adopted, which which I think indicates even that much more that there needs to be more process, there needs to be more time, there needs to be more evaluation with all of the stakeholders, and I ask for your support of this amendment.
Mr. Speaker.
Thank you, Madam Speaker Pro Tem, and I rise in strong opposition to this amendment. We heard that we should study this issue. So I'm in my last year of my legislative career. I've served 7 years, and we've been studying this issue every single year, and every time a bill comes up, the cities say, let's study it. We've studied it. We know what's going on. We don't need to study it more. This isn't a compromise. This is a gutting of the bill. That's what this is. We heard that it's for economic development. Great. Economic development. If it's about economic development, then have the cities put their money in the game. That's all this is saying. Put your money in the game if you think this is good. Don't tell the school districts, the fire districts, the sewage districts, all the special districts that they have to put money in the game and you're not ready to put money in the game. If this is good economic development, then you should be willing to put money in the game. But the cities haven't been willing to do that. And this is, if we do this, this is fair for cities. For too long, we've been unfair to our counties and our special districts and our school districts. Let's finally be fair to them. And this is an affront and a gut punch to local government. I'm sorry. Isn't the school boards elected? Aren't our county commissioners elected? This current system is a punch in the gut to them because they have no say on their taxing. All we allow here and the current system is saying that the cities can give away the counties and the school districts and the special districts money without any say. I'm sorry, I trust my counties. I trust my school district to know what's best to how use their money. And that's all this is saying, actually. It's actually not even saying what I would like to say is you can't take their money unless they actually vote for it. This says, okay, at least put your money in the game if you want to take our money away. Okay? And the idea that this applies to Denver. Well, Denver says they work with their school districts, and it's only one school district. That's their biggest taxing entity, and they do work very well with the school district. For the city and the county, they're the same thing. So here's the conversation. Do you agree? Yes. Do you agree? Yes. Okay. We have a deal. This has very little to no impact on the city and county of Denver. It won't stop projects in the city and county of Denver. And the idea that the money is we can't do this because the money in the sales tax is already dedicated to ECE. Well, as Representative Sonnenberg said, we've passed mill levies to go to fire districts, go to water districts, go to school districts. That money's dedicated too, and you're giving it away. This is about fairness, fundamentally about fairness for our local governments. About saying that you should not give away the taxing ability of a special district or a county or a school district without that, at least you putting money in the game. This is one issue, and if my last year, and I really applaud Representative Del Grosso, the minority leader, for taking this on. This is one thing I regret that we've never been able to take care of. This doesn't go far enough, in my opinion, but it goes down the right path. We are going to, the current projections, actually, let me go to one more point, because Representative Schaefer raised the issue of the mill levies and the fire districts going to the mill levies. Well, why do the fire districts have to go to the mill levies? Because the cities are giving all their revenue away. That's why they have to go to the mill levies and increase taxes on people, because the cities are saying, we don't care that you got that approved. We're going to give your money away. Let's stop raising mill levies and actually give the local special districts control over their money. So, as we really try to end this, and as I end my legislative career here, in the legislature. This is the one issue I am sad we haven't tackled and actually seen something done about. And I'm hopeful this year we can actually do it with this bill. Because the projections, this is the thing that no one's talking about, the projections. If the current system continues the way it is, you want to talk about the negative factor? The negative factors, this impact is going to be over $200 million to our schools. $200 million within 5 to 10 years to our schools. Is that really what we want? Do you want to try and make a dent in the negative factor? Then don't allow people to give away the local mill levies and local property taxes away from those school districts. So I understand the cities hate this, but this is about fairness to say we should allow the local cities, if you're going to give away other people's money, put your money on the table. If you're not ready to put your own money on the table, then if not good enough for you to put your money on the table, then you shouldn't put other people's money on the table. I'd ask for a no vote on this gutting of this bill and a yes vote. Well, we already voted yes on the bill, but a no on this, and then on Monday when we go on thirds, a yes on this important bill for our state.
Representative Fisher. Representative Moreno.
Thank you, Madam Speaker. I rise in support of the LEBSOC amendment, Committee of the Whole amendment. I've remained largely silent on this issue, but as a former city councilman, I guess I take a little bit of offense to the suggestion that cities don't care, that cities don't care about what the impact this has on school districts or on special districts, because I can tell you that nothing is further from the truth. As a former city councilman who was involved in setting up an urban renewal authority, I know where the financing for TIF comes from, and it's not something that I took lightly, ever. The reality is, and we've heard a lot of inferences made, that this is this shell argument of cities versus schools. Well, I'll tell you something. When those school kids have to walk next to abandoned buildings to get to school, that's a concern. And that's why cities utilize this tool like urban renewal authorities to redevelop those areas, because they know how important it is to spur economic development in the community, but also to redevelop these infill areas, to redevelop these blighted areas that are a safety concern when kids walk to school, that are a safety concern in terms of crime and issues in the community. And I'm not saying that there haven't been abuses in the past with urban renewal. There have. And when appropriate, the legislature has stepped in and put a stop to those abuses. And I commend the previous work that's been done on that issue. But the reality is to look at doing this in a way that will prohibit cities like mine from utilizing urban renewal authorities, because the reality is that sometimes those sales taxes are dedicated. Like in Commerce City, when we passed a sales tax initiative increase last election, that money is dedicated to infrastructure projects and to parks projects. It is not something that we can then just offer up as a matching funding for urban renewal. That's not the case for my city. So I guess I just take a little offense to this whole issue of cities versus schools, because I can tell you that local government officials know what impact it has on schools, and a lot of times the urban renewal authorities that they do set up are trying to help the kids in those communities. I ask for a yes vote on this amendment.
Representative Fisher.
Thank you, Mr. Speaker. I was thinking maybe you were going to have the last word, and I didn't want to upstage the speaker, but since it looks like other people are going to speak after you, I will as well. I urge a no vote on the LEBSOC amendment, and I share the speaker's passion for this issue. It's something that I've worked on for most of my legislative career, and I too want to leave this building knowing that I've done everything that I can to help remedy some of the real unfairness and just the complexity of the Urban Renewal Authority statutes that make it possible for people to work around
and really take advantage of it in ways that it was never intended to be used. And that's why I oppose this amendment. And I want to just, I suspect, and somebody can point out that I'm completely wrong on this, but I suspect that in Golden, what the downtown development was there was a DDA, maybe not a URA. And the DDA statutes, we renewed the DDA statutes not too long ago. And the DDA statutes have a share back now after we renewed them. They didn't previously. The DDA is the only other entity that I'm aware of that uses a tax increment to help offset the development costs. So when we renewed the DDA statutes, we made sure that the counties and the other taxing entities were held at least not totally harmless, but had at least some share back of the revenue that was being generated. And that, to me, is what this bill is all about. That we are actually asking the cities in this way to share the revenue with the counties, or at least not take all of the revenue with them. So I also want to just point out that nobody's really brought this up yet, but I believe that there's a serious Tabor issue involved with tax increment financing schemes that hasn't really been addressed. And unfortunately, this bill doesn't address them entirely, but I think it starts to make at least some inroads into addressing those issues. You talk about the school district that passes a mill levy override, for example, or a special taxing district, the fire district or the protection public safety district, whatever you have. They have to go before the voters to ask for an increase in their tax base or their tax revenues through that ballot measure. And then there's nothing at all that keeps a municipality from coming in and saying, well, your voters just passed this under Tabor. They had to go to the electorate to get permission to do this, but we're going to just take a little bit of that money with us. Without any vote of any elected body, they are just able to do that without any regard to what the citizens of that taxing entity just did. And to me, I'm really frankly surprised that that's never been challenged in court. My city, the city of Fort Collins, is adamantly opposed to this bill. And I generally try to do what my city asks me to do and oppose bills that they oppose. But in this case, I believe that I stand here more on principle than out of loyalty for my city government on this. This is a principle that means a lot to me and to a lot of other people. And I know that former Senator and now Larimer County Commissioner Steve Johnson is probably listening right now and maybe watching on TV. And I know he's out there trying to fight for justice for the counties and the other special districts that are being hurt by this. And Evan Golding, the executive director of the Special Districts Association, told me one time, you know what the URA statute is? It's just allowing people to do economic development and redevelopment with other people's money. And they need to have some skin in the game if they're going to do that. And I think this, by having this requirement that they come to the table with some of their own money, will change the calculus that they go through when they're deciding which projects to TIF and which ones are not. I think it'll be a much different, I think the feasibility of some of these projects will look much differently if the cities have to come forward with some of their own tax money. So for those reasons and for many, many others, I urge you to vote no on this amendment.
Representative Singh.
Thank you, Mr. Speaker. And members, anybody who says that Tabor has a problem or school financing has a problem doesn't understand either, because it doesn't take money from the school districts. That doesn't happen with TIF. But what does happen, why school districts do approve of this, is because of the rooftops that pop around these urban renewal districts, because people want to live there again. That's how they get their money, is the per student head count. And we're also not taking in consideration some of the businesses come in from out of state because of this funding mechanism. Members, the but-for argument is accurate, and most cities use this. There are some bad actors, but most use this in a good way to attract business, to attract investment. And it's kind of like a business investing back into the business to make it better. Because otherwise, you're going to have 50-year-old, 100-year-old crumbling buildings. You're not going to have a thriving downtown. And just for an example, there was a Gallup poll out on Healthways Wellbeing Index, and Colorado made the top 10 once again. And some of the 5 cities that were mentioned, which are Boulder, Colorado Springs, Denver, Fort Collins, and Greeley, all have URAs. And they have one of the best well-living indexes. Thanks.
Madam Majority Leader.
Thank you, Mr. Speaker. And I probably can't say it any better than you did. I appreciate your very passionate approach to this issue. But I really do feel like I have to say a few words about this. First of all, I want to thank Representative Del Grosso for bringing this very important bill this year. The solution to the issue of URAs, urban renewal, and tax increment financing is long, long overdue. And this bill, in many ways, is a simple and very, very excellent solution. It will lead to better and more fair approach to urban renewal. And there have been used in this debate many times the word economic development. This is not an economic development tool. This is an urban renewal tool. And I was very involved in defining the systems of urban renewal back when it first started in about 1967 or so. It was established by President Johnson and the Congress at that time. And it was a very important program designed to alleviate blight and slums in urban areas. Too often in the state of Colorado, this has been used for pure economic development. Pure economic development so the cities, the municipalities, can gain the sales tax from the developments that occur, and it is a huge subsidy in that regard to developers. Now, I think that would be fine if we had defined in our law that, in fact, this tool should be used for pure economic development. That is not the case. And that is why this study, in my opinion, is simply not necessary. We have all of the information that we need and have for many years to come up with some significant solutions to what I think is an oversubsidy that isn't needed. Now, I do not believe, nor do I think, that this bill does away with urban renewal. Quite the contrary. I think it supports it in every way. And it allows for the orderly development for pure urban renewal in cooperation with all of the taxing entities. The cities, primarily for their general fund, for their general tax purposes, use the sales tax. The special districts, the school districts, and the counties rely primarily on property tax. So it's very easy for the city to apply the school districts, the special districts, and the county's property tax, future property tax increase to these developments, and sometimes they do some sales tax, often they do not, and the most abusive ones of these do not. Now, under this bill, everyone will have some skin in the game, and that's very important. In that regard, it really does give the local governments, the counties, the special districts, and the school districts a place at the table. Just having one member on a board of 11 or 13 or something is not going to give those people a place at the table. That is a misnomer, in my opinion. It's a good start, but it certainly doesn't do anything. So first of all, this does not do away with urban renewal. I'm sure you will see many projects go forward. They have in the past, with city putting sales tax into the game, with cities developing arrangements with their special districts and their school districts and their counties to move forward. That will all happen, but it will help alleviate the huge abuses we see and the huge increases in tax increment financing. Now, one thing that has not been mentioned that I think is very important to talk about, and we've talked about fairness to the special districts and so forth, but we have not talked about fairness to the average taxpayer. And quite frankly, I agree. I think there is a Tabor issue involved here because it increases the average taxpayer's taxes, particularly in the areas, and that would be, quite frankly, a lot of rural areas where there is no really good reason to do tax increment financing, and they don't. And those people are helping to backfill the amount of property tax that's taken away from schools. And I would beg to differ respectfully with Representative Sain. In fact, that is the proof of what happens to school districts. We backfill the school districts through the School Finance Act to the tune of at least $40 million a year, and it would be a one-for-one $80 million a year if it weren't for the negative factor. And that is going up every year. It will soon be much more than that. That is a very significant amount of money, and there is a report that shows that. That, in my opinion, is a real disjustice to and a unfairness to the average taxpayer that doesn't benefit from any of this development, that just simply has to pay the state taxes to do that backfill. And we now pay for around 45% of our budget in the School Finance Act. And that doesn't even count for doing away with the negative factor. So there's a real fairness here with regard to taxpayers. This bill will go a long way to begin to solve that problem. And I believe it is a first best step that we've seen in a long time, a very straightforward step that will, in fact, begin to reduce the abuses in this program and will give the special districts, the school districts, and the counties the ability to have some say in what goes on with their property tax. I ask for a no vote on this amendment.
Representative Fisher.
Thank you, Mr. Speaker. Members, I knew if I misspoke, somebody would call me out on it, and so I just wanted to make sure. Apparently, the golden example was a URA, not a DDA. So I apologize if I wasn't trying to mislead anybody. I prefaced my remarks by saying that I wasn't sure if it was or not. The city of Fort Collins has done almost all the redevelopment in their core downtown area with a DDA. And a DDA has a share back provision with the other taxing entities, the counties primarily. And if it's good enough for the DDA, I think it's good enough for the URA as well.
Mr. Minority Leader.
Thank you, Mr. Speaker. Do I get 10 minutes or 20?
You can have as much time as you want, Mr. Minority Leader.
No, don't worry. Members, there's been, quite a bit of stuff that was said here, and we argued this quite a bit on seconds as well, going through here. I just wanted to address a couple of things that were brought up. And one of the things we kept hearing in committee all the time is cities do bring money to the table. We provide a bunch of infrastructure. We do bring a lot of stuff that's upfront money. Well, that's true. But what's also true in most cases, they actually pay themselves back for the infrastructure improvements that they did with sales tax or property tax money from the counties. So they talk about, we brought millions of dollars to the table on these deals, but the increment in property tax, they use that to actually pay themselves back. So yes, they might have brought upfront money to the table, but like I said, they're paying themselves back with somebody else's money. I think we kept hearing, well, this is but for money, so really the counties shouldn't complain. Well, that's true, it's but for money, but why is it not but for money when you're talking about the sales tax as well? because that sales tax also wouldn't be there if it wasn't but for. So that goes back to my premise that we are only talking about increment here. So when everybody talks about, well, the city can't afford to put their sales tax in, this is the increment. This is the extra sales tax that wasn't there before the project. This is the extra property tax that is there now that wasn't there before. So we're talking about people sharing and putting in equal amounts of the extra property tax and sales tax. They're not reaching into their general fund and having to put in a bunch of money that they already had somewhere else. And we heard, well, cities have dedicated taxes and that's unfair to make them put that in. Well, we also heard stories from the counties that without their say, the cities can obligate the dedicated taxes back into this URA. I have Foothills Gateway, which serves developmental disability folks in my community. And they have a dedicated tax. And guess what? That increment gets put towards these projects. And I'm pretty sure they would say that when the voters approve that extra, that they would like to actually have it go to them and not go to that project. Or maybe they had a seat at the table and they were actually there and they actually had some say in the city of Fort Collins and the county, and they all come together and says, you know what, guys, we're all chipping a little bit, but here's the positive impacts that it's going to have on our community. Can we all agree to put a little bit in? And then they work some kind of deal out. But now it is basically, there is no need to have to do that because the cities hold all the cards. And so I guess if you've got all 52 cards, then it's a kick in the gut to actually have to give somebody else one or two of those. So you only have 50 of the 52. I guess that's a kick in the gut. But the counties provide services too. All kinds of social services, jails, DAs, they pay for elections. They do all different kinds of things. They have expenses too. So to say, well, counties just sit back and collect a paycheck and absolutely have to do nothing and don't have any skin in this, and so why should they complain at all? That is absolutely false. Members, this amendment would take away the equal share back to say only if you can't agree. So many of the cases that Representative Lebsack talked about, he listed out all of these towns. We had many of those mayors. We spent hours of having mayor after mayor after mayor come to committee and talk about, well, here's 3 URA projects that I have in our community. And they talked about how it was set up and what was going on. And then we found out the way it was set up. We're like, well, Mr. Mayor, did you realize that the way that's set up, this bill wouldn't apply? Well, so to think that this will actually shut down these projects is false. The reality is most of these projects are happening now without this, and this would not affect this at all. Members, I urge a no vote on this count.
Seeing no further discussion, the question for the House is the passage of the Lebsack Amendment to the report of the Committee of the Whole. Mr. Kohler, please open the machine and members proceed to vote. Representatives Buck, Buckner, McNulty, and Salazar. Close the machine. On a vote of 30 aye votes, 32 no votes, 3 excused, the Lebsack Amendment to the report of the Committee of the Whole is lost. Mr. Kohler, please read the sane amendment to the report of the Committee of the Whole.
Representative Sane moved to amend the report of the committee to hold diversity action taken by the committee not adopting the following same amendment L022 to House Bill 1375 to show the said amendment passed and the House Bill 1375 as amended passed.
Representative Sane.
Thank you, Mr. Speaker. I move the same amendment to the Committee of the Whole and ask that it be properly displayed.
It's properly displayed to the amendment, Representative Sane.
Thank you, Mr. Speaker. Members, we've been told this bill has been sold as one seat at the table, one seat at the table. Well, there's some cities, I have 3 of them, that have spanned 2 different county boundaries. And as far as I know, all the URAs are in one county. So all it simply does is allow the commissioners to pick who is going to be the seat at that table. So I urge a yes vote.
Is there any further discussion? Representative Labuda.
Thank you, Mr. Speaker. Members, I urge a no vote on this amendment. By statute, these URAs are composed from anywhere from 5 to 11 members, most of them 11 members. If 2 members become commissioners, is that going to upset the balance of power? No. It's simply allowing counties to have a say at the table, to be listened to. I urge a no vote on this amendment.
Seeing no further discussion, the question for the House is the passage of the same amendment to the report of the Committee of the Whole. Mr. Kohler, please open the machine and members proceed to vote. Representative Salazar. Close the machine. On the vote of 16 aye votes, 46 no votes, 3 excused, and 0 absent. The same amendment to the report of the Committee of the Whole is lost. Mr. Kohler, please read the Waller amendment to the report of the Committee of the Whole.
Representative Waller moved to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Waller Amendment L014 to House Bill 1388 to show that said amendment passed and that House Bill 1388 as amended passed.
Representative Waller. Just giving you time to get down there, Representative.
Thank you, Mr. Speaker. I move the Waller Amendment to the report of the Committee of the Whole.
To the amendment, Representative Waller.
Thank you, Mr. Speaker. Members, we had a long and vigorous debate on this bill today. And we couldn't get where we wanted to get regarding how this bill treats unborn children. So that makes this amendment very necessary. Members, this bill purports to provide civil remedies for pregnant women who lose their unborn children. And this bill purports to provide damages as that remedy in these civil actions. Those damages include the woman's own economic damages. Those are damages that result from economic loss, not being able to go to work, costs that come out of her own pocket, costs that are related to time in the hospital or whatever. Those are direct economic losses. The bill also purports to provide non-economic damages. Non-economic damages are pain and suffering, things of that nature that are related to a loss. And it also provides for exemplary damages, punitive damages. Well, this bill is supposed to be about providing that civil remedy to these women for the loss. Now, currently in Colorado statute, and we heard Representative McLaughlin say this numerous times, currently, if a woman loses her unborn child to one of these actions, and there can be a wrongful death claim brought, and that woman can recover non-economic damages to include the loss of the unborn human being. That's the current state of the law. So the current state of the law says simply, if a person can have non-economic damages or can be awarded non-economic damages if they lose a loved one. So if a wife loses a husband, she can collect damages in that wrongful death action. She can collect damages because she's had a loss related to the husband. She's had a loss of love, a loss of companionship. She engages in pain and suffering as a result of the loss of the husband, so she can get economic damages, non-economic damages. The current state of the law is if a woman loses an unborn human being, she can now gain those same non-economic damages based on that theory. She's lost companionship. She's lost love with that unborn human being. Well, in order to be able to claim these damages, these non-economic damages, there has to be a loss. And it has to be a loss of someone. It can't be a loss of a car. It can't be a loss of a pet. It can't be a loss of some tangible object. It has to be the loss of someone. But the problem now is this bill says that an unborn human being is not someone. It specifically says that. And it says it, page 3, line 9, without establishing the legal personhood of an unborn human being. Because we're saying a baby is not a human being until it's born live, we're effectively saying it's not a human being at all until it's born live. And because it's not a human being, when it's born live, it's not a person. And if it's not a person, then non-economic damages for loss of love, non-economic damages for pain and suffering related to the loss of a person cannot be granted or awarded to a woman because by definition in this bill, an unborn human being is not a person. So my amendment simply does this. It is a technical amendment, nothing more. It doesn't move the dial at all when it comes to the personhood discussion. It doesn't change it one way or the other. It just simply does this. It preserves current Colorado law. It doesn't change the definition at all of non-economic damages. That definition remains the same. It remains exactly the same. The only thing this amendment does is says, for non-economic damage purposes, you can claim those non-economic damages for the loss of that unborn child. You can claim those non-economic damages for the loss of companionship that you would have otherwise had with that unborn child. You can claim non-economic damages for the loss of love you would have otherwise had for that unborn child. All this amendment does is preserves the current state of the law in Colorado. Now let me tell you what happens if this amendment doesn't pass. Make no mistake about this, members. If this amendment does not pass, we are actually making it harder, more difficult. This bill will make it more difficult for a woman to claim non-economic damages in a civil action than she can today. So this bill won't protect or won't provide further protections in regards to non-economic damages for women who lose their unborn children. It will actually make it more difficult for a woman to gain non-economic damages for the loss of the unborn human being. So if you vote no on this amendment, you're saying we're going to make it more difficult, harder for a woman to gain non-economic damages for the loss of that unborn human being. All I'm trying to do here, members, is this. Let's keep the current state of the law. If this bill is truly about providing a civil remedy to mothers who lose their unborn children or that unborn human being, then let's do it. Let's not say we're going to do it and then not do it. Let's actually make it happen. That's why this amendment is so crucially important to this piece of legislation. Let's preserve the current state of the law and let's allow those mothers to still be able to claim that loss. to be able to claim that loss of love and that loss of companionship and the pain and suffering related to losing somebody that's in their life. Let's preserve that civil remedy under the law by voting yes on this amendment.
Representative Foote.
Thank you, Mr. Speaker. We're asking for a no vote on this amendment, members. And what I want to do is I want to point out what the plain language is of this bill. Page 4, starting line 6, a woman may bring an action for damages in accordance with this Part 12 against any person who intentionally, knowingly, or recklessly caused an unlawful termination of pregnancy. That's plain language. That's in the bill. That is the bill. And it goes on to say, a woman entitled to bring an action under this section may recover the following damages. And it goes through economic damages and non-economic damages. That is the plain language of the bill, and it should be clear by now, and I'm sure if anyone listening will find out, that is the absolute intent of this bill. Now, when courts look at differing arguments about interpretation of language, sometimes what the court will say is, if there's two different interpretations and one would lead to an absurd result, we'll go with the other one. And what this amendment does is it leads us to an absurd result. It basically means that the bill, if it passes and becomes law, is meaningless because it would override the plain language that I just read to you on page 4 of the bill. So members, this amendment is unnecessary and we would ask for a no vote.
Representative Murray.
Well, Representative Lebsack, you indicated that the non-economic damages are outlined. Well, they are not in this bill. And that's the whole purpose of this amendment, is to say, what is the loss? So to get non-economic damages, you have to say what's been lost. And I've been pregnant twice. And when you say, well, you're going to lose a pregnancy, that's not what you're grieving over if you lose that baby. You know, many of us will say, well, when pregnancy is done and we have that baby, we're glad to be rid of that pregnancy. We're not talking about the loss of a pregnancy. And we haven't even argued about the title of the bill. We have not challenged the title of that bill, loss of pregnancy, or unlawful termination of a pregnancy. But when you get to damages, you have to say what has been lost that the woman is grieving over. It's not the big belly that she's grieving over. It's the loss of a baby. And so that's what needs to be defined in this bill. And I don't see that it gets in the way of any of the other intentions because human being is used elsewhere in the bill. So it's not like we're not using the word person here. We're using the word human being, and that's in the bill elsewhere. So it goes along perfectly with the sponsor's intentions of the bill. So I urge an aye vote on this amendment.
Is there any further discussion? Seeing none, the question for the House is the adoption of the Waller Amendment to the report of the Committee of the Whole. Mr. Kohler, please open the machine, and members proceed to vote. Representative Scott. Oh, sorry, Representative Scott excused. Thank you. Close the machine with 24 aye votes, 36 no votes, 5 excused, and 0 absent. The Waller Amendment to the report of the Committee of the Whole is lost. Mr. Kohler, please read the Gardner Amendment to the report of the Committee of the Whole.
Representative Gardner, move to amend the report of the Committee of the Whole to reverse the action taken by the committee in not adopting the following Gardner Amendment L011 to House Bill 1388 to show that said amendment passed and that House Bill 1388 as amended passed.
Representative Gardner.
Thank you, Mr. Speaker. I move the Gardner Amendment to the report of the Committee of the Whole.
To the amendment, Representative Gardner.
Thank you, Mr. Speaker. And members, I had hoped we would be a little later than 7:15 before I started my drive to take the calendar over till the next day on adopting the report of the Committee of the Whole. But it appears as if I will have to simply rise to the occasion for 4 hours and 45 minutes. Or
You got 9.5 minutes left of that 4 hours. Representative Gardner.
Thank you, Mr. Speaker. I just thought I would, before people realize what the rules were, crank up their sense of well, their sense of fatigue at the very least. Seriously, members, I do not want to take a long time on this issue. We had a robust debate about it. The proponents of this bill say that this bill is about providing a remedy for a pregnant woman, a remedy that does not exist. I asked them repeatedly to tell me what is that remedy that doesn't exist. The fact is that what this bill does, whatever their assumed intention is there, this bill forecloses the personhood of an unborn human being. It forecloses it. It doesn't walk a fine line, as one of the sponsors said. It chooses a position on that issue. What this amendment does is says we do not choose any position on that issue. The purpose of this is to provide a remedy. Nothing in this act shall be construed to either confer or deny legal personhood to a human being at any time prior to birth, or any rights associated with that status, as the purpose of this act is limited to that stated in paragraph A of this subsection 1. Well, paragraph A of subsection 1 says, and I don't have it in front of me, but it basically says the purpose of this bill is to provide a remedy. If that is truly what this bill is about, then this amendment should be adopted and make this bill truly what it is about only providing a remedy, not choosing a position and the personhood debate, which will rage outside this building no matter what we do. I ask for an aye vote.
Is there further discussion? Representative Pedersen.
Thank you, Mr. Speaker. And this does provide a remedy without importing personhood and making sure that, yes, we do exclude it to ensure that there aren't any repercussions, that we aren't interfering in women's health care. And we've talked extensively about this, and I ask for your no vote.
Seeing no further discussion, the question for the House is the passage of the Gardner amendment to the report of the Committee of the Whole. Mr. Kohler, please open the machine and members proceed to vote. You kept just going back and forth, Representative Foote. Representative Pabon, Humphrey, and I'll let you get back to your seat. Representative Pabon, close the machine. With 24 aye votes, 36 no votes, 5 excused, and 0 absent, the Gardner amendment to the report of the committee is lost. There are no more amendments to the report of the committee of the whole. Mr. Kohler, please open the machine, and members, please vote on adoption of the report of the committee of the whole. Representatives Becker and Priola. Has everyone voted the way they wanted to vote? Being the case, Mr. Kohler, please close the machine. With 59 aye votes, 1 no vote, 5 excused, and 0 absent, the report of the committee of the whole is adopted. Members, great work today. We got a little later than we wanted, but you can take off till 10 a.m. on Monday. Announcements and introductions.
Thank you, Mr. Speaker. Members of the House Agriculture, Livestock, and Natural Resources Committee, you'll find on the calendar on Monday that a bill has been added. Senate Bill 164, the aerial tanker bill, will be heard at 1:30 in Ag. And then also, members, you probably have seen this article on your desk today. Hopefully you took note of it. I had it placed there because on Monday, we will have the chefs that participated in the Farm to Fork Cook-Off event on Ag Day on March 26th. We'll be here in the chamber, and we're going to present them with a tribute, each of the chefs a tribute. So take a look at this article. It was presented compliments of the Colorado ag producers. It talks about the Farm to Fork Cook-Off, and look forward to seeing those chefs here in the chambers on Monday.
Any further announcements and introductions? Mr. Kohler, do we have anything to read across the desk?
No, sir.
Okay, Madam Majority Leader.
Thank you, Mr. Speaker. I move to lay over the balance of the calendar until Monday, whatever it is. April 28th.
April 28th, I think. April 28th. Seeing no objection, the balance of the calendar will be laid over until Monday, April 28th. Madam Majority Leader.
Thank you, Mr. Speaker. I move the House stand in adjournment until Monday, April 28th at 10 a.m.
Seeing no objection. Just waiting. Seeing none. Bueller. Seeing no objection, the House will stand adjourned until Monday at 10 a.m.